Good afternoon, everyone. Welcome to the Appellate Division, First Department. We have oral arguments for today, January 13th. So please ask for the time that you actually need in order to get out the salient points of your arguments. We are fully familiar with your briefs and with your arguments as well. People v. Latrice Carr. That matter is submitted. Lending Assets v. Gerby.
6 minutes on argument, and if I could, 2 on rebuttal.
Yes, respondent. 5-2. You have a cross appeal? No. 5-2 and 5. Matter of GE Children. That matter is submitted. Ochoa v. CI Lobster Corporation.
Maria's here for the appellate. 5 and 2.
5-2 and 4. Padilla v. 76 11th Avenue. 5-2-3. 64 West 10th Street v. El Rey LLC. That matter is submitted. People v. Joseph Campbell. That matter is submitted. People v. Jonathan Rodriguez. Good afternoon, Your Honor. 5-1-5. GAD v. CC NFP. There is no appellant. Did you wish to submit? Matter is submitted. Thank you. People v. Omari Brown. That matter is submitted. Simone v. City of New York, or Simeon v. City of New York. 5-2 and 5. Shanklin v. Wilhelmina Models. 6-2-5. Flores v. New York City Health and Hospitals. You have a cross appeal? 6 and 2, 5 and 2. Coronel v. Markel Contracting. Five two, 5-2. People v. Jail and Doctor. 4-1-4. Gans v. Leach Tishman.
10 and 5.
I'm sorry, Tishman. Five two, 3, 5-2. Goss Lawson v. Matco Service Corporation. 4-2-4. Barrero v. New York City Department of Social Services. 4-1 and 4. I gave you 1 minute on rebuttal. People v. Mitchell Thompson. 4-2-4. U.S. Bank National v. Brown. That matter is submitted. First case for argument is Lending Assets v. Gerby.
Good afternoon. May it please the court. David Fiveson for the appellant. Your Honors, this is a straightforward appeal. And
As opposed to a
difficult,
non-straightforward appeal?
opposed to a difficult appeal.
Okay. No, I'm sorry, go ahead.
The appeal, the error stems from the lower courts incorrectly interpreting.
Well, the whole
The
issue, or
allegation.
one of the issues, was the Martinez complaint, wherein, according to Supreme Court, in the Martinez complaint, you totally went, contradicted your allegations. I'm saying what the Supreme Court stated, that you contradicted the allegations in your complaint in this matter regarding who was responsible for what.
That's the fundamental error here. The lower court, in page 9 of the record, says that the fundamental element of my claim is that the defendants should record and insure, INSURE. We do not claim that the defendants who were in New York counsel were to issue the title insurance policy.
What would they retain to do?
They were retained, based upon Mr. Gerby's affidavit, they were retained to supervise and insure, EN, to make sure the title agent in Florida recorded it and obtained valid policies.
That's what the retainer says?
There is no retainer, and because there's no retainer agreement under the Rheingold case, the Kleeman case cited, Court of Appeals, it is what is the reasonable expectation, the scope of the retention my client would have had. So my client is giving $1.2 million, $1.4 million mortgages in Florida. It has a title agent that's going to do the closing, record the mortgage, and issue a policy.
The title agent was independently hired by your client, right?
No question. But Mr. Gerby's
The
office,
title agent is independently hired by your client. How is the law firm then responsible for what the title agent, an independent hire, does?
I don't claim he is vicariously liable. My claim is that he had a separate independent duty in New York. He was paid
Based upon what?
Based upon my client's expectation. Mr. Gerby stated that he was to review the documents in his affirmation.
You said it was based upon an expectation? Was it based on anything documented?
Yes, Mr. Gerby's affidavit says that it was his duty to make sure all the necessary documents to complete the transactions are obtained. That's at 187.
So saying that they are obtained is one thing, and verifying their accuracy would be another, correct?
Well, if he's just acting as a potted plant, yes, but he had notice that that was a fraudulent policy because he emailed the agent and said, it is imperative you get me the closing documents.
Right.
And that agent, and before he releases the monies,
Right.
and that agent, and that name of Apex Insurance, any lawyer practicing law knows that that is not a recognized title policy. He was on constructive notice
Is
of
it
that.
that is not recognized or that it does not exist?
Doesn't exist. Doesn't exist.
And so this takes us back to the Martinez complaint, wherein the statement was totally inconsistent, again, with your allegations here. Because in the Martinez complaint, again, you stated that there was no reasonable expectation that the defendants would complete the tasks related in terms of insuring the mortgages.
Martinez affidavit is not inconsistent.
Complaint.
That complaint, because that duty was a separate duty from that of Mr. Gerby. Mr. Gerby was hired as New York counsel to make sure that and that closing was proper. He verified in his affidavit, it was my duty to obtain all necessary documents. And his email, he says, it's imperative you get me the documents. He's not going to release the monies. He's acting as a closing agent
To get
also.
the documents is one thing, but to verify the accuracy of the documents is entirely another thing, where a different agent was hired for that purpose, right?
Well, I disagree respectfully. I'm not saying he's vicariously liable. He, as a lawyer, has a separate duty, and he cannot delegate that duty to a non-lawyer. Why else was he being paid $13,000, $14,000 just to issue to draw up a promissory note in a mortgage in Florida where he wasn't even practicing? His duty in New York, and this is a 3211 motion to dismiss, and it is our contention that given his admissions in his affidavit and in the email, we cannot conclude that the claims have no merit. And therefore, it
You
should
have
have
time
been.
on rebuttal.
Thank you.
Yes, you may proceed.
Good afternoon, Your Honors. For respondents, Gabriel Gerby, Esquire, and Welts Keikos Gerby, Wallenetz, Volinsky, LLP. I actually think that this is a straightforward appeal. and that the Supreme Court properly dismissed the complaint because plaintiff's own judicial admissions and the undisputed closing
What was your
documents.
client hired to do?
That's a great question, Your Honor. And if I'm quoting the affidavit, and this is the customary practice of what a lender counsel does in a mortgage and a real estate transactions, WKG was hired to prepare the loan documents, to review the title reports as provided, to identify any encumbrances to be cleared, and to ensure that all required documentation was collected and executed to permit funding.
So were they
And that-
to verify, does that include verification of the information as your friend argues?
Absolutely not, Your Honor. And to hold that way would be to transform a real estate lawyer into an insurer for a title agent, a title insurer, and a party's business partner. That's
But does that not flow though? Why why would it be required that they obtain the documents, I guess for review? I'm sorry, why would it be required that they obtain the documents if not for reviewing those documents into ensuring that there's proper filing?
well, the recording happens after it's
Yes.
funded, and that's absolutely within.
Well, what about reviewing for accuracy?
Well, it was reviewed for accuracy that the title insurer is supposed to, or rather that the real estate attorney is supposed to review the title report, and if any encumbrances to title come up, you bring up those issues to the parties and resolve them if needed. This whole business about, being on notice that there was fraud, first of all, that's not in the pleading. And, that this was a sophisticated fraud. Unfortunately, this person was criminally convicted in fraud, and there were numerous other victims of a sophisticated scheme. And, the title,
The fraud
fraudulent
was not
title-
apparent on the face of the document, as your adversary has argued?
I don't think so, Your Honor. I represent lawyers, but I'm not an expert in this area, but it looks like a title report to me. It has all of, the parties and all of the information that you would expect to be on a title report. Lists the proper properties and so forth. So, I think that the court is hitting on all of the main issues here, and the key point that one of your honors made was that making sure that all of the documents are obtained to effectuate the transaction, preparing the loan documents. That's not the same as verifying the accuracy of the documents, and that's not to say that hypothetically, in a other certain situation, that could be the real estate attorney's responsibility, if that's contracted for, if there's a retainer agreement to that effect. But if you look at the plaintiff's complaint, all that they base and their brief, all that they base their argument on, their scope of duty on, is his client's reasonable expectation and this extension of non-delegable duty from the Court of Appeals case of Kleeman versus.
Do your client have an obligation to ensure that the mortgages were recorded?
I would say no. That's what a title company does. That's why they're paid. That's why they were paid in this case, and that's part of the documentary evidence that we submitted in support of the motion.
So are you saying that it would be redundant to also have the attorney verify that all of the information in the title report was accurate, and also to verify that the mortgages were recorded?
I would say, in my understanding of the way this practice usually works, the answer to that question is yes. But hypothetically, parties can contract to do whatever they want to do. If client Smith wants to hire Attorney Jones to be a supervisor and to discover, whether his client's business partner has committed a fraud, you can pay an attorney to do that. But that's not what happened here. That's not my understanding of the usual course. Real estate attorneys have one function, title agents have another function, title agents have title insurance, For that reason, I see that my time is coming up. I think the
Oh,
court.
your time is up. Thank you.
Okay, thank you.
Just briefly.
So, counsel, my colleague mentioned that or asked a question as to whether the fraud was clearly whether the fraud was on the face of the
Yes,
document.
I can tell the court I represent all the major title underwriters.
So was the fraud in this case clearly on the face of the documents?
Yes, when Dora sent up the title report to be insured by Apex Insurance Company, anyone that did real estate transactions would know that is a bogus company.
That
No
Apex
question.
was a bogus company?
No question. And it's our
Regardless
claim.
of how the title report looked, that it looked
Who was
legitimate.
signing it? The company doesn't exist. It's not one of the major Fidelity, Commonwealth, Old Republic. It's not an underwriter. If this court can Google my name, I have maybe 150 reported
No, we wouldn't Google your
decisions in this
name. The
area.
issue is Apex, not you. So
But I'm
how would this
saying-
attorney know that Apex was bogus?
Because he's an attorney retained as an expert in this area, real estate, to handle the closing, and any lawyer would have known that.
But was it the lawyer's responsibility to find out whether the company that the title agency company utilized was a bogus company?
He concedes it was his duty to obtain all necessary documents.
Well, that's to obtain the documents. That's different from saying that he has an obligation to obtain the nature of the business listed on the document.
Or conduct any further investigation?
Well, that's the allegation, and I refer the court to the Kleeman case, which we cite, which in the absence of a retainer agreement, there is no written retainer agreement, it is what the client's reasonable expectation is of what the scope of the duties of the lawyer that undertakes. And in this instance,
Counsel, if I may, I mean, it's clear that the attorney was not retained to record the mortgage, correct?
no question.
All
It
right,
was to-
because, I'm not done, I'm almost
I'm
done.
sorry.
Because in the complaint, and I'm referring to the Martinez case, there was the specific allegation that Apex was hired to be the title agent and required to record the mortgage in the first instance, right?
Correct. She's down in Florida. He's in New York. My client's in New York. My client's lending over $1.5 million. He's acting as a settlement agent, meaning he doesn't release those monies. He says it in his email. It's imperative that I look at it and approve it before I release the monies. And he says in his affidavit, it was my duty to obtain all necessary documents. A necessary document is a valid title policy. And I'll just end with this. It is their burden to show that those documents conclusively rendered my allegations false, without merit. And one cannot say that based on his admissions and the absence of a written retainer agreement, that the allegations, not the ones the lower court said we thought he was going to go to Florida and retain it, and he was going to issue the policy. He was not issuing the policy.
Thank you. Thank you very much.
Thank you all.
Ochoa v. City Island Lobster Corporation. Yes, you may proceed.
May it please the court, my name is Maria Zier, and I'm the attorney for the appellate, plaintiff appellate. The issue before this court is one, the issue before this court is, should a court adjudicate a case on its merits or on a ministerial procedural defect? This court favors resolution of cases on merits and not on ministerial errors. Dismissing cases based on ministerial procedural error.
Is this a ministerial procedural error, or rather striking the complaint based on a delay that the court felt was a deliberate, intentional delay in the case?
It's our opinion that it was a ministerial defect.
But was there an order which your client did not adhere to?
No.
No.
That's the problem of this case, is that there was a case scheduling order issued in this case, a single court order. And plaintiff already in this, you know, a case scheduling order, they say, oh, you know, like, you know, plaintiff to exchange, you know, discovery demands by this date, plaintiff to, you know, provide a bill of particulars by this date. Plaintiff provided her bill of particulars. She responded to the defendant's discovery demands. She also, you know, served.
Well, she didn't respond fully to the discovery demand, correct?
She responded fully. Defendant wasn't happy with the responses, but that doesn't show that she was willful and contumacious.
So the court at some point does dismiss it, is that correct?
Well, they accidentally dismissed the action.
And it's clear from the record that that dismissal was an accident.
Correct.
And so after it's accidentally dismissed, what occurs? Does anything occur during that period of time, after the dismissal?
After the dismissal, I was the handling attorney of the case, and I saw that it was marked off. After, you know, I saw there wasn't any movement, so I saw it was marked off. I was very kind of confused, like most attorneys would be. Why was my case marked off? You know, a case
But didn't the
scheduling order was
defendant, didn't the defendant follow up and send notices or requests to you for some type of action, for responses to the discovery, et cetera?
They sent good faith letters, yes, they did. However, they never contacted the courts for any further, you know, to take any further action. They waited until plaintiff didn't know what, you know, figured out that they needed to make a motion to restore the case to the calendar.
How long did that take between the time that the case was marked off the calendar and when you realized that?
I believe it's, I'm so sorry.
That's okay.
I believe it was approximately 6 months. I did personally make phone calls to the court. It's not in the papers, but I did make phone calls and I couldn't get through to the court. So that's why there was a motion made. And the defendants then jumped on that, you know, kind of jumped on the bandwagon and were like, oh, this is a great opportunity to make a motion to dismiss. But prior to that, they never reached out to the court. They never tried to set up a conference.
With regard to the deadline to file the note of issue, were you able to file a note of issue if the case was marked off the calendar?
No, we couldn't file because we didn't have any depositions. Discovery had to continue. That's why the case had to get.
You had no active case, right? It wasn't an active case on the court's docket.
No, it was not. After it was erroneously marked off.
So basically, what you're saying is that on one case scheduling order, there's no proof that your client was willful and contumacious in failing to provide discovery.
It's not just the court order. We did respond to the initial discovery demands, and then the defendants served their good faith letter saying that they were not happy with our responses and wanted further.
So did the case scheduling order have a remedy in the event that there was a dispute as to any items of discovery?
No, because we never really got to that point.
Well, no, if there's a dispute, were the parties not to then go to the court in order to resolve the dispute?
We should have gone to the court. The defendants never made any sort of action or motion.
Well, that would be the remedy under the case scheduling order.
Yeah, instead of waiting until trying to restore the case so discovery could continue, so depositions could be set up, so note of issue eventually could be filed, defendant just sat there and did nothing until plaintiff tried to remedy the situation.
Now, I know defendant is claiming you didn't comply with discovery, but you also served discovery requests. And did the defendant respond to those discovery requests?
That is not part of to be fair, that's not part of this appeal. But
Well, then
yeah.
you can't go outside the record. Thank you.
Good afternoon, Your Honors. I represent defendants. This is a case where the sanction of dismissal was absolutely proper.
So once the court, once there was a case, an order from the court in terms of discovery, et cetera, and the plaintiff did not adhere to it, why would you not then go to the court and ask for some remedy at that point because the discovery, et cetera, has not been turned over?
Well, what we did is we continued to pursue the plaintiff with the amount of And I do believe that it is the responsibility of the plaintiff to pursue their case, okay? The idea of making that our burden, I think, is a questionable
Well, not so much,
situation.
I don't think the issue is your burden in this instance. Do you concede that the court erroneously marked us off?
Yeah, and we did concede that, and but the point here, it goes deeper than that. It goes into what were those responses that the plaintiff did do when they finally did. And by the way, when it comes to us sending letters, our letters went from,
Counsel,
went all the way from
Counsel.
May 23 all the way to July 24.
since when is a good faith letter an order of the court?
It's an alert to the plaintiff.
So then the case scheduling order says that if you cannot agree on an issue of discovery, then you are to contact the court for either a conference or what is it that you're supposed to do? Make a motion to compel or to strike. Was any of that done?
The motion was made when this motion was made.
I'm going back, because actually, this is in the record. When you cross-moved to dismiss, plaintiff opposed, and at the record, page 263, paragraph 6, plaintiff talks about the fact that they requested discovery, and you failed to provide it.
And this was untrue, and it was part of the reason why we went before this court with a motion on the appeal level, and I think it reflects in my papers how much diligent work I had to do to make sure that documents that should not have been in the record were taken out of the record, and there were still problems after that.
Let me ask you this question, because when I went through the record, as I said, page 263, paragraph 6, where the plaintiff says defendants did not respond, my question is, can you refer me to a page in the record when you did respond?
yes,
Because I didn't see it.
Yes, it was in the July, we provided all the responses that we needed to. It is in the record, and it was, I believe we're talking about.
You know what, while you're looking, let me pose another question to you.
Response to plaintiffs.
Page 265 of the record, July 18th, 2024. Now, certainly there were things that were outstanding that the plaintiff didn't provide, but isn't it fair to say that when the motion was noticed, I believe it was like, let's say, July 20-something, isn't it fair to say that the plaintiff did respond to all of the things supposedly that were outstanding?
No. Well,
go to
it
page
is-
265.
They did not. First of all, we did do our responses that are in the record, and no, they did not. And let me start off with this. The verified bill of particulars, there is not one in the case. There is not one. Counsel puts the word verified in, neither is. You have them, 3 years after the accident saying, yeah, if you find a receipt, we'll give you a receipt. No, and after we told them to preserve documents, no, she doesn't have the shoes anymore. There is so much, never giving a social security number so that when,
Counsel,
but you can't.
procedurally,
Yeah.
we're addressing the procedure that was employed here. You have a scheduling order. The scheduling order is it's not self-executing. So the court erroneously strikes the case from the calendar. At that point in time, why did you not make a motion? Why did you wait until they attempted to revive the case?
Again, I do believe that it was plaintiff's obligation to proceed if we were not, what we were doing was making our good faith attempts to get the discovery, to start things moving. In the interim, there were the dates like the, file the note of issue, things like that. And honestly, I guess at some point, we could have, moved to dismiss earlier. I mean, but again, we were trying to work with what she had provided, and it was wholly, you couldn't even proceed on a case with what she had provided to us.
Justice Mendez.
And I,
Wait, Counsel, Justice
Counsel,
Mendez.
yeah.
So I'm going to read to you from the case scheduling order, which you should have had. And it reads at item 11, it says, in the event the parties cannot agree on an outstanding discovery issue, despite good faith efforts, which you did, to resolve the dispute without court intervention, a discovery conference may be requested. Said request shall be emailed, it's got an email address, and then it says, and details of the attempt made to resolve the issue between the parties. So you're supposed to say that. And then it says, non-compliance of these directives may result in the delay of the scheduling conference. So that was your remedy. It was included in the conference order. If they were not providing the discovery materials that you were requesting, your remedy was to contact the court and schedule a conference. That didn't happen. We went from scheduling a conference to a motion and striking the pleadings. In other words, you jumped the gun.
I thoroughly disagree. We did not.
I'm
We
pretty sure you
provided
do.
discovery. They did not. It was totally wrong what they did. And then my personal thing is, when I got to address this on appeal, the amount of issues I then had to deal with in creating and correcting their record just shows me, demonstrates what this court is, what the Supreme Court would have to be dealing with all over again if this court were to determine
Well,
that this
you know,
was
that's
my
not really,
obligation.
that's not really the.
But
Thank
again,
you. Thank you
yeah.
very much.
The defendant brings up that they wanted supplemental, responses to their discovery.
Well, what about the fact that there was no verified complaint?
It was I believe there was, but if there wasn't, we can fix that. That is easily fixed.
Well, you know,
You
that, I
can
think
find
that
there,
goes to
a
her
copy.
argument that this has been going on for a while. If you didn't know that there's no verified complaint, then that's something that should have been fixed a little earlier, right?
Yes, I would have to go back and check what was not verified or verified. It's been my practice to make sure things are verified, so we don't run into issues like this. In these good faith letters where the defendants are asking for, supplemental responses to the BP discovery, some of the things that they're asking for, they're not entitled to, and they're not, they think they're entitled to, like the client's.
Defendants also state that there were no, and apparently plaintiff admits this, no efforts whatsoever to communicate with them regarding the case. They sent 5 good faith letters to you seeking outstanding discovery, all of which went unanswered.
I do believe everything went unanswered. Communication definitely could have been better, and I do take responsibility for that. However,
Part of the record indicates that the plaintiff characterized those letters as harassment. What was harassing about them?
because we had to get the case back on the calendar, and it was over and over again. We did respond to a lot of the discovery they requested. So for example, they requested her client's social security number in their demand for bill of particulars. Pursuant to CPLR 3041A, we're not required to give the client's social security number. There's about 7 things you can ask for, and that's not one of them.
So when that request is made, you do not simply ignore it, you respond accordingly. But according to the defendant, there was no response whatsoever, as opposed to stating why you were not turning over certain discovery.
It was in the original bill of particulars. It would have been,
So then you would
objection
refer,
beyond the scope of CPLR 3043 or A,
so then you would refer to that in your response to their communication.
which we did in our response to their good faith letter once they served the motion.
Thank you both.
Thank you.
Padilla v. 76 11th Avenue. Yes, you may proceed.
Good afternoon, Your Honors. Stephen Eastner from the law firm Bartlett LLP for the appellant defendants. This is a single issue appeal. It concerns the application of the integral to the work
How is
doctrine.
this an integral part of the work?
Well, the plaintiff in this case was working on framing a wall. His own testimony was that the debris over which he allegedly tripped was used in the framing of those walls.
Was it used by him in the framing of the wall, or was it, I mean, is the record clear that that debris was the one that he created, or was it debris that some other trade or company created at the premises? Or was it debris that had been there from prior days that was supposed to be removed by laborers?
The plaintiff testified that it was like or very similar to the materials used by his employer in framing the walls. When he was asked whether it was the same materials used by his employer in framing these walls, he said, "I suppose so." As you pointed out, Your Honor, the record here is sort of thin, and I just don't think there's enough proof here for the motion court to have properly granted summary judgment in plaintiff's favor. Plaintiff's own testimony has some inconsistencies and just some absences that I think are sufficient to raise issues of fact.
How would the removal of the debris have interfered with plaintiff's ability to perform the work assigned?
That's a good question, Your Honor. And it's unclear what methods would have been put in place to remove that debris from the record. Again, the record is very thin. It mainly relies on plaintiff's own testimony. The only other testimony in the record is from an employee of my client,
The
OmniBuild.
one who said that the practice was to pile everything up in the middle of the floor?
I believe that was what Mr. Quinn testified, that they would center pile, and then plaintiff's employer was using that very material the day before, if not earlier in the day of plaintiff's accident, and there may just it may.
But do you not, in order to succeed, do you not have to show that the removal of the debris would have somehow interfered with plaintiff's ability to complete his task?
I think in order for our motion to dismiss the 241-6 claim to have been granted, yes, but in order to raise an issue of fact in opposition to plaintiff's motion for liability in his favor on 241-6, the answer would be no. It's a different standard. And here we just have issues of fact about whether or not it was integral to the work. If it's shown that it was integral to or was not, then we would move on to that next element if we were assessing the plaintiff's motion. But here I mean to focus on the opposition to plaintiff's motion, not
So,
defendant's motion to dismiss.
I think it's Zykowski, ZYKLWSKI v. Chelsea Warren Corporation, a case that we decided in 2025. Did we not say that you have to show that the removal would have that the removal would have made it impossible for plaintiff to do his work?
Yes, I believe that is an element, but again, I believe that would be in the dismissal of the plaintiff's claim, not in the motion for liability in plaintiff's favor on this industrial code.
But you're relying upon that defense stating that it was integral to the work in opposition to plaintiff's motion.
Yeah, absolutely. Both that it was integral to the work and that plaintiff did not establish as a matter of law that it was not integral to the work. So it's a prima facie issue as well as whether there's an issue of fact.
So you're saying Zykowski has no bearing on this case?
I think it's an element of this case, but it is not such a clear-cut issue that this court should not consider reversing the grant of summary judgment in plaintiff's favor.
Thank you. You have time on rebuttal.
May it please the court, Lori Parkman for plaintiff respondent. I guess I'll start where you ended, that to raise a triable issue of fact on the integral to the work defense, the defense itself requires, and the Court of Appeals made this clear in Buzz Derrick, that it must be inherent to the task at hand such that preventative measures would make it impossible to complete the work. That's the defense, and you need to raise the defendant would need to raise a triable issue of fact to support that. There's nothing in this record that would support that. First of all, the plaintiff was not engaged in any framing. The plaintiff was using a drill to remove screws from the studs and disassemble a wall and reassemble it a couple inches over.
So he was not cutting any metal.
He was not cutting any metal, and no one on the floor that day was cutting any metal. The
So
record
the debris that was there from a prior day.
Yes, the plaintiff's testimony was that he was working there alone, that he did not perform that job, not just that day, but that was not his work. They truncated the quote. He was asked, were those metal pieces garbage related to framing work performed by your employer? He said, I suppose so. I cannot tell you certainly because I was not there when they were performing that job. And he testified he didn't know when the metal was cut. He did not perform that type of work. And the record also shows not just his testimony, but the daily log shows that there were only 2 other people on the 7th floor that day, and they were insulators. So these metal pieces, it's undisputed in the record that the metal pieces were left there from a prior day. And Buzz-Darrick makes, I mean, even before Buzz-Darrick, this court said that an accumulation of debris from previous work does not meet the defense. I mean, because every piece of construction debris or scattered materials was once used in the work. To say that it's sufficient that it was used at some point in the construction job would completely eviscerate the code that requires them to not leave debris laying around for days. And then since Buzz-Darrick, this court's made clear again in Lourenco in 2024, which specifically rejected the view that it was sufficient just that it was used in the employer's work at some point. The law here is clear. It must be inherent to the task at hand. And there was nothing about plaintiff's task of removing screws and taking down wood and moving the wood. He had nothing to do with the cutting of these
But
metals.
wasn't the metal framing, though, wasn't that part of his duties to remove because apparently this had been done incorrectly?
These were, the pieces on the ground were cut pieces. They had been cut and discarded. Plaintiff explained
No,
that.
but wasn't his task that day to fix, right, there had been errors in terms of the framing, so wasn't his job to fix the metal framing?
No, he was fixing the location. He testified he went up on the ladder and he took out the studs. He unscrewed the studs from the wood and then disassembled and moved it. He had nothing to do with cutting any metal whatsoever. If this had been a case like the Ziris case that we cite in our brief, where the plaintiff was engaged in removing rivets and they were dropping them to
So
the
his
floor,
task
and
that-
he's trapped on that. But this is not that at all.
So his task had nothing to do with metal or pieces of metal?
No, he said he was not there when the work was done that created these discarded. He didn't know when it was done. He didn't perform that type of work.
And I think, did he also testify that he told, I think Edwin, or I think the gentleman's name was Edwin, about the debris?
Yes, that morning at 11:30 that morning, he complained that there were, and this wasn't just a couple pieces, there were many just strewn about. And he complained to his supervisor, who specifically told him, it's not your job to clean up, just work around it. So.
Thank you.
Thank you.
Just a few more points to address. With regard to the daily log, it's inherently unreliable because it doesn't have plaintiff working on that floor at that time, at that day. Really, there's only the 2 installers or insulators. So if we're going to...
Counsel, he's not dealing with metal at all, apparently. There's no metal or pieces of metal involved in his task.
Absolutely. The metal was used to frame the walls. He was working on those same walls. That's why I'm advocating for a little bit broader application of the integral to the work doctrine as this court applied in Krzyzanowski, where it said that the motion court too narrowly applied it. I believe that's what happened here. And applying the applicable standard here, there are at least issues of fact about whether or not these metal pieces that were involved in framing the walls on which he was working at the time that he was injured was integral to the work.
Do we know when that wall was built?
We believe it was completed the day before the accident, but because it needed to be moved over a few inches, Plaintiff says he was sent down to from the floor he was working on to a different floor, and he was asked to make some alterations involving moving the wall over. And he says he was not involved with metal, but we know that metal was involved with the building of these
So
walls.
did you present any witnesses or any evidence that, to suggest that he was involved with metal?
So,
That his tasks had anything to do with metal or removing metal pieces, et cetera?
right, so plaintiff's employer is not a party to this action, and there was no witness from his, either Edwin, who supposedly he was complained to about this condition. So it was really only an employee of the general contractor that testified. And again, the record is thin. There's no doubt about it. So really, we're just relying solely on plaintiff's own testimony, which is contradictory in some ways, including about specifically what his task was, how he was doing it, who else was there, where were and the daily logs don't really do much to corroborate plaintiff's version of the facts.
Thank you. Thank you both. Thank you all. People v. Jonathan Rodriguez. Yes, you may proceed.
Good afternoon, Your Honors. Kathy Liu, Center for Appellate Litigation, representing Mr. Jonathan Rodriguez. This court should order a resentencing because due to probation's failure to conduct a timely
So
pre-sentence
he
interview.
he pled guilty to the Rob 3. He was sentenced to 1 to 3 to run concurrent with the New York City. He had a New York County case, excuse me. And he's currently on parole. Is that correct?
No.
Oh, he was on parole at the time that he committed this this case.
Oh, correct.
Right, he was on parole at the time.
Yes. Like I was saying, the court should order a resentencing because due to probation's failure to conduct a timely pre-sentence interview, Mr. Rodriguez was unlawfully sentenced on a statutorily deficient pre-sentencing report that was completely devoid of updated and current information regarding his personal history.
So what, had there been a pre-sentence report, what would be the difference between the report that he was sentenced on and the new report?
Yes, Your Honor. So had he been interviewed by probation, there would have been questions asked by probation regarding his personal history. The report that was used for his sentencing, it didn't contain any updated information regarding his personal history. On pages 6 to 7 of the report, in the sections regarding his family circumstances, about his employment, his physical health, mental health, and substance abuse, it said current information could not be obtained, but instead, these sections of the report only incorporated outdated and stale information from a prior pre-sentencing report, information that was gathered 7 years earlier. So had there been an interview, there would have been updated information that Mr. Rodriguez would have.
Was this a negotiated plea wherein the promise was 1 to 3?
This was a negotiated plea, but the promised sentence was 22 years of incarceration. And at sentencing, the judge, Judge
My
Mandelbaum.
point was, would any additional information in the pre-sentence report, would that in any way have affected what the sentence was going to be?
Yes, it would, because again, the promised sentence here was 22 years. Mr. Rodriguez did not get the promised
He
sentence.
didn't get the promised sentence because of his conduct afterwards, right? It had nothing to do with the pre-sentence report or his history or anything having to do with the present crime.
So the sentence enhancement was based on his breach of the return to court condition,
Right.
which is a condition of the plea.
How would have an interview in the pre-sentence report have aided the court in that?
Because there is no updated information about Mr. Rodriguez's mental health. The pre-sentence
Does the
report.
pre-sentence report always include mental health issues?
Yes, and that's actually one of the statutorily required, it's a required category information that under the statute, CPL 39020, or 39030 subsection 2 requires.
So at the time of sentencing, did the attorney make any representations as to the defendant's mental health history?
No, Your Honor. So the defense.
Did you preserve this argument?
Yes, the issue is preserved. This is on pages 7 to 8 of the sentencing minutes. Defense counsel brought to the sentencing judge's attention that Mr. Rodriguez had not been interviewed by probation and requesting an
Ask for
adjournment.
him to
Ask for-
withdraw his guilty plea based on this?
No, but that's not required, Your Honor.
Oh, I'm sorry, so how was this preserved? What did the defense attorney do at the time of sentencing?
So at the time of sentencing, this is on pages 7 to 8 of the sentencing minutes. I can read it to you, Your Honors, if that would be helpful. Counsel said, Judge, I would simply ask that you, I'm sorry, I'm reading the probation report indicates probation was not able to interview him because the interview was actually set up for tomorrow. It might be in everyone's best interest if we table this matter for a few days, put it into next week so that he can be interviewed by probation. They can get his statement, whatever it may be, and we have a completed report. Even if he decides he doesn't want to give a statement, that would at least be in the report, and the
So
court
that
then
he
denied
could give
that
a
request.
statement. It was nothing about investigating any mental health issues or anything of that nature.
That is part of what is implicit in the request. Like he needed
No,
to
what
talk
is
to-
implicit in the request appears to be so because the defendant was not able to give a statement as to the new arrest,
No, it was
the new case.
no. The statement was actually he had never been interviewed by probation. So that was what the defense counsel was referencing when
What
he
you
wasn't
just
able to
read,
give.
what you read was so that he is able to give a statement whether he wants to give a statement or not. Is that what you just said?
No, it says the probation indicates probation was not able to interview him.
No, what is he requesting? He said, let's put it over for tomorrow so that, pick up from there.
Oh, right. So defense counsel brought to
could you read that again? Pick up from where you
Yes.
started.
the probation report. This is on pages 7 to 8. The probation report indicates probation was not able to interview him because the interview was actually set up for tomorrow. It might be in everyone's best interest if we table this matter for a few days, put it into next week so that he can be interviewed by probation.
And go on, and if he wants to give a statement or not, right?
Yeah, they can get his statement, whatever it may be, statement meeting the conversation.
No, I know what statement means.
Yeah.
So, but that's what
have
I'm
a complete-
stating.
and have a complete report. So the defense counsel's complaint is that the report is not completed.
Because the defendant was not interviewed and the defendant was not able to give his statement.
Right, but part of giving
My
his
colleague asked whether this was preserved in terms of any issues that would be brought to the court's attention, which would affect the promised sentence.
yes, so our position is that was sufficient to preserve the issue, but in any event, this is a challenge to the legality of the sentence, and this court has recognized even in last term in Pizarro that it cannot be,
Counsel, I have another question for you. You know, what weight should we give to our decision, People v. Lashley, which is certainly cited in the People's Brief, where, this court ruled that a new sentencing procedure would not be warranted because a pre-sentence interview is not a legal requirement, particularly where the sentence was the result of a negotiated plea, and the court had, sufficient information about the defendant's social, psychiatric, substance abuse history, et cetera, et cetera.
Yes, so Your Honor, our position is that Lashley is not applicable because here, Mr. Rodriguez did not get the negotiated bargain for a sentence. The bargain for a sentence was
That may be
22
true,
years.
Counsel, but he didn't get it because he violated a condition. It wasn't that he didn't get it because the court decided that it's no longer going to honor the promise. So that's a separate issue with regards to the pre-sentence report.
Your Honor,
So in other words, even if there was a full pre-sentence report where he was interviewed, based on what he did, his conduct in refusing to coming to court, throwing feces around and all the other stuff he engaged in, that was grounds in and of itself to not honor the promised sentence.
right, Your Honor, we're not challenging, our
You're
argument
conflating
is,
the two now.
well, am I able to, can I respectfully clarify, Your Honor? So it is the law, right? The law requires that in imposing a sentence, whether that is following a trial, or in this case, imposing an appropriate sentence enhancement, the court has to have enough information to make a a fair sentence, right? And under the law, this is under People versus Key and People versus Farrar.
I don't believe that that's correct. A pre-sentence report is not illegal. A pre-sentence interview is not a legal requirement.
I understand, but in those cases, they're distinguishable because there was no prejudice there, right? The
And as my
defendant-
colleague, Justice Kennedy just stated, under Lashley, we have stated that you don't need that. The fact that there is none, does not require a new a remand for resentence. And as my colleague Justice Rodriguez stated, the reason he did not receive the promised sentence was because he didn't return to court. So the pre-sentence report would have had nothing to do with the sentence that was imposed.
So, Your Honor, the sentence enhancement of 3 years, the court gave that without having any information on
The
new
information
mitigating
that the
circumstances.
court had was that I told you to return to court and you didn't return to court.
Right, but under People versus Farrar and People versus Key, the court can't just impose a sentence only for the purpose of retribution. The court had
It's not
to have,
retribution, it's because you did not follow my statements.
based on my conversation with,
You did not follow the conditions of the ROR.
right, but there might be mitigating circumstances there, right? The client might have mental health issues. He might have substance abuse issues. None of that
was
information
raised here.
before-
None of that was raised here.
Again, under Pizarro, because this
No,
is challenged to the
meaning
legality of
raised by the attorney. The attorney never mentioned anything about the reason that the defendant did not return to court was because of any mental health issues or anything of that nature. There was nothing stated by the attorney as to why the defendant didn't return to court.
Well, our argument is that the pre-sentence report needed to have information about statutorily prescribed topics. This is a straightforward application of the statute.
What bearing does
390.22.
any of that have to do with the enhanced sentence for violating the condition of his plea?
Because the court needed to understand what was going on with the defendant, right?
We read
Court is-
we read the minutes. The court completely understood what happened with regard to the defendant absenting himself from returning for sentencing.
The court was basing its decision only on what the prosecution asked for, which is 3 years.
So at the
there was
time that
no
the def-
mitigation in the record on his mental health.
At the time that the defendant took the plea, was the defendant told that if he returned to court, he would receive X sentence, and if he did not return to court, he would receive Y? Was he told that? He was.
He
Was
did,
not?
but he wasn't told he would get 3 years specifically.
Was he told that he would not get the promised sentence if he did not return to court?
Correct. And in determining the
And so
appropriate-
you're stating that there would have been something in the pre-sentence report, which again is not a legal requirement in terms of his being interviewed, that if the defendant were interviewed by probation, that somehow would have informed the judge as to what the sentence would be.
Correct.
And that's not speculation.
Well, we don't know what would have come out during the interview, but
That's the
whole
definition
point-
of speculation. Thank you. You have time on rebuttal.
Okay.
May it please the court, Matthew Colangelo for the people. When the defendant refused to return to court for sentencing, he breached the plea agreement, and the court was entitled at that point, as the court had admonished the defendant he could do. This is at page 124 of the plea.
But he
proceeding.
wasn't told what the enhanced sentence would be if he did not return to court. I mean, normally, I think a lot of us who practiced on the criminal side, we would say, okay, if you return to court, you're going to get 20 years. If you don't return to court, then you're gonna get the maximum, or you're gonna get 25, or something of that nature. He was not told what his exposure would be if he did in fact not return to court.
So, Your Honor, he was told, this is at page 124, quote, "If you fail to meet any one of these conditions, you will not get the promised sentence. You will not be able to take back your plea. Instead, I will sentence you to a term of imprisonment, which can include consecutive sentences on the counts allowable under the law." Now, at sentencing, when the defendant failed to return, the court did not impose consecutive sentences on all of the remaining weapons and drug charges, even though he was authorized to. Instead, he imposed a 25-year sentence for the manslaughter plea, but honored the plea agreement to impose concurrent sentences on the remaining charges. Now, those sentences expose the defendant to an additional 71 and a half years of incarceration. So the defendant was fully apprised. Yes, Your Honor.
That was going to be my question. Was defendant informed as to what consecutive sentences meant?
Well, Your Honor, there's no further elaboration other
Not
than the court's.
Anywhere else in the record?
Well, yes, Your Honor. In the plea colloquy, the defendant was advised. Well, the defendant negotiated and received a promised offer of 22 years for manslaughter with specified numbers for the remaining counts, all to run concurrently. So he understood that absent the plea, he was facing consecutive time, not concurrent time, on all those.
Was he
weapons.
told that if the court wished, all of those sentences could run consecutive?
Yes, Your Honor. I think that's pretty clear at page 124 of the minutes. The judge said all of these other sentences can run consecutive.
But he ran it concurrent, right?
But he ran it concurrent. Now, sort of more fundamentally, I think the question here is, to the extent there was any deficiency in the pre-sentence report, which the people don't believe there was.
Well, the defendant was not interviewed, right?
Well, as Your Honor pointed out, there's no requirement that the defendant be interviewed. There's no statutory requirement that the defendant be interviewed. The requirement is that probation investigate a certain set of categories of information and prepare a report containing the information that agency believes is relevant to the
Well, I
question of
guess your
sentence.
friend's argument is that if the defendant had in fact been interviewed, then he may have stated the reasons for his failure to return to court, whether he had mental health issues or substance
Well,
issues.
so two responses to that, Your Honor. First of all, there's no evidence anywhere in the record other than in the pre-sentence report, which mentions an earlier prescription for Seroquel at Bellevue. There's no record in the trial record at all of any mental health issue, and the court had full opportunity to observe the defendant over the course of the lengthy pretrial and trial proceedings, observe the video of this offense, observe the intentional nature of the crime. So it's not entirely clear where the sort of hypothetical notion that his mental health may have affected the offense conduct in a way that would have warranted lowering his sentence after he breached the plea agreement. But
And anything that would have been contained in a pre-sentence report about that would have been self-reported rather than anything that was verified, right?
That's right, Your Honor. But more fundamentally, if the defendant had wanted to explain his mental health, his physical health, the reasons for his behavior, express remorse, he could have gone to court for sentencing, but he didn't. Instead, as Your Honor pointed out, he threw feces at court officers when they tried to bring him into the courtroom. And the appellate division, in evaluating questions regarding the adequacy or the sufficiency of the pre-sentence report, has asked both whether there was any prejudice, but also whether the defendant, either by appearing himself or through defense counsel, could have apprised the court of that information in another way. Here, the defense counsel had represented him for years, was fully familiar with his circumstances.
Also, the pre-sentence report here satisfied the statutory requirements where the Department of Probation relied on old information.
I'm sorry, Your Honor, I didn't hear the first part of your question.
The pre-sentence report here meet the statutory requirements when the Department of Probation clearly relied on information that was about 7 years old, I think it was.
The pre-sentence report, yes, for a subset of the categories regarding his employment, family circumstances, and health, the probation officer relied on a dated report, yes. But it still met the statutory requirements because, as this court has evaluated, if I may finish my answer, Your Honor.
Yes, please.
Thank you, Your Honor. As this court has evaluated, the question is whether, taken as a whole, and more practically, whether the sentencing judge had sufficient information in order to make an effective determination.
And you got to keep in mind also that it's a negotiated plea. I mean, he didn't get the promised sentence for other reasons, but otherwise he would have gotten the promised sentence presumably. That's
right, Your Honor. If I may add one more sentence, as a practical matter, the question for the trial judge in this case was whether, with a homicide victim's family in the courtroom having taken off work, ready to appear and give their statutorily authorized impact statement, and where they had said to the court that they were not available to return on any convenient date in the future, whether in those circumstances the court was required to adjourn sentencing for a hypothetical interview to
Whether
get
it was even prudent to do so given the defendant's history of refusing to appear in court.
Exactly,
Right,
Your
and
Honor.
that's what counsel stated that, because counsel stated whether, he's going to be interviewed or not.
That's exactly right, Your Honor. Thank you.
Thank you.
Your Honors, so this court just made clear again just last year that in order for a PSR to be adequate, it has to contain current and updated information pertinent to the imposition of a sentence. And while the case law recognizes several exceptions to the adequate PSR requirement, none of those exceptions are applicable here. The courts have recognized that there is an exception to being sentenced without an updated and adequate PSR in instances where the defendants received the minimum sentence or the exact promised sentence, such that not having a PSR
That was not up to date would be the statement by the defendant. Is that correct?
No. All of the sections in the report that are statutorily required under section 390.
So you're attacking the entire report. You're stating that the entire report was, that the pre-sentence report in its entirety was insufficient.
No, I'm saying that under 390.30, it specifically says that the pre-sentence investigation and the report must consist of information regarding the offense conduct, the history of the defendant's criminal history, and then various aspects of his background, including his social history, employment history, family situation, economic
And none of that
status.
was included in this report?
None of it was current and updated. All of it was stale, outdated information from a report that was prepared 7 years earlier.
So you would like us to do what?
We would ask
Vacate the sentence,
and
return it to remand, have the defendant interviewed by probation, and give a statement to probation, and then have the court resentence the defendant.
Yes, it was critical here that the defendant be sentenced on a statutorily adequate PSR.
And so what is your response to the fact that the defendant refused to be interviewed, refused to come to the courtroom at the time of sentencing, and threw feces at the corrections officers?
Yes, Your Honor, that is wrong. It is absolutely inexcusable. But the law is clear, right? This is a straightforward application of CPL 390, 20, and 30, and this court's precedent. A defendant it says on 390, 20, the sentencing court may not pronounce sentence until it receives a written report of its pre-sentence investigation. And then 390, 30 sets forth the contents that has to be in the report, and it includes information about the defendant's background, and specifically in 390.32, it says whenever information is available with respect to the defendant's physical and mental condition, the pre-sentence investigation must include the gathering of such information. That was not done here, and
Wait a minute.
as I
How
said,
do you know that was not done? Because he wasn't interviewed?
correct. And
And so,
Information solely comes from him?
right, so as my colleague stated, this is all self-reporting, right? So you would want probation to then interview him so he can state, oh, I have mental health issues, and this is why I threw feces at the officers, or this is why I refused to come to the courtroom?
can you repeat that again, Your Honor?
It's okay. Thank you both.
Thank you.
GAD v. CCP NIFP. This was a submission.
They came back. No.
So I was going to admonish you for being late, but then you come in injured, so it becomes a little bit difficult to do so. The sympathies, I guess, would be on your side. So I stated that I would give you both 5 minutes. Your friend had been here earlier. You may proceed.
Thank you, Your Honors. May it please the court, Martin Schell on behalf of Appellant Defendant CCNFP. Appreciate the opportunity to appear and apologize for my tardiness. I think the papers here, Your Honor, speak volumes, which is fairly simple, that there was an agreement signed that said a non-refundable deposit is to be made. There was no force majeure.
So the event was to take place on May 17, 2020. Is that correct?
That's correct.
And so this was during the height of COVID.
Yep.
we have the executive orders from the governor, which talk about the social gatherings, and it was because of this that the event could not take place on May 17, 2020. Is that correct?
That is my understanding.
And we're talking about a bar mitzvah. Is that correct?
That is my understanding, yes.
And so I'm assuming, I do not know because it doesn't make clear in the record, that there's a reason for that May 17, 2020 date. Was that the date of the young man's birthday, which is why we're having the bat mitzvah on that day?
I cannot speak to that. I don't know, but what
Well, we'll assume that's correct. So May 17, 2020, it does not occur. Your client does not notify plaintiff, if I'm correct, until May 19, 2020, which is 2 days after the event, right?
I know they were speaking, Your Honor, and there were efforts to basically move the event to another place. My understanding, Your Honor, is there is a distinction between the bar mitzvah, which is, I guess, the ceremony of becoming a man, and the event to celebrate that milestone.
Okay, but the event was supposed to be May 17, and on May 19, your client notifies the plaintiff that they're working on an addendum, right, to reschedule.
There were certainly conversations to reschedule that.
Those conversations happened after the event was supposed to happen, right?
I believe so, yes.
Right. And then the addendum, which was referred to by your client on May 19, that addendum was not provided to the plaintiff until July 1, 2020.
There certainly could have been a brief period.
And then plaintiff declined the rescheduling on September 13, 2020.
That sounds about right, yes.
Okay.
There are emails that identify those points in time, Your Honor.
And so your argument as to why, first of all, there was a valid contract. We know there's a valid contract.
Yep.
And I think it kind of went back and forth as to whether or not there was a deposit or wasn't a deposit, because I think at some point you said, well, we're really not sure that we received a deposit. But then you said, yeah, we did receive a deposit. And so the basis for not returning the deposit wherein you were unable to fulfill the terms of the contract?
Well, just to be clear, Your Honor, there were two payments. There was a $25,000 payment. Unfortunately, that was paid in cash. It was paid subsequent to the filing of these motions. There was proof brought forward that says that they paid an employee of the defendant. Yes.
$25,000 cash payment to Klein.
Right. And she has not been an employee of that business.
You've already conceded that there is no question about that, right?
I don't know. I haven't spoken to that employee. I don't know where she is.
I think in your papers you conceded, yeah.
I think it's fair to say, Your Honor, that if he paid the $25,000, he should get that back.
Okay.
I am
Why are
certainly
you saying
focused.
if, though? You've already conceded that it was paid.
I don't have anything to my knowledge that disputes it was paid. He has a statement that says,
Well, Supreme Court noted CCC's concession that plaintiff paid the $25,000 in cash. That's at record 7. So let's proceed. Keep going.
I would say, Your Honor, the issue is does $27,218.75 go back to the plaintiff?
Yes.
And I would say to you the answer to that is no. Or at the very least, there should be a hearing to determine what, if any, of that amount should go back. Because my client had cost. Anytime, the reason why you have...
Right, in your papers you said something about that your client required the wait staff and other individuals to be present, and I think vendors, et cetera.
Yeah, it has to pay a staff. It has to keep a staff to make sure that they can service these events.
The closures and restrictions on the numbers of people at spaces happened in March. We're talking about an event that was scheduled to occur in May, and you knew, your client presumably knew that you wouldn't be able to have the number of people that this event required, right?
I think there's law that says that the COVID restrictions are not a defense are not a grounds for impossibility. Okay, that this event could have been moved to another date. The plaintiff engaged in those conversations, did not immediately say, oh, my event did not happen, I want my money back immediately in March, April, May, June. He waited until September.
Did the agreement speak about the possibility of changing the date?
I don't know if it spoke of it, but there was an addendum sent where they could...
But they didn't have to accept that addendum, did they?
They did not. They could have said.
And the agreement certainly didn't speak to it because there would be no need for an addendum if it spoke to changing the date.
Well, the agreement says if you're going to cancel the date, there's a penalty.
But they didn't cancel the date.
They ultimately did cancel, Your Honor. We afforded
No,
them.
they didn't cancel the date, the May 17, 2020 date. They did not cancel that.
Well, they could have. I don't recall exactly if New York City was open or closed in May. We may have been coming out and making advances, okay, in terms of doing a smaller event or a different kind of event. I'm sure people were going back to work as most of the shutdowns occurred in March and April, okay, so we are past all of that.
Right, but you did not come back to them until May 19, which was 2 days after the event.
There could have been conversations before then, Your Honor. I don't know them. I don't
Well,
have
I mean,
emails.
I'm only speaking to the record.
Right,
I
fair
don't
enough.
see anything in the record that states that there were any conversations prior to May 19. You're correct, there may have been.
We didn't have a hearing. We didn't
So
have
are
the
you
opportunity
familiar
to
with
do that.
the case, it's a second department case, but it's KV Heavenly Events and Catering Corporation. It was decided in September of this year, 2025. Facts are very similar to the facts here. And in that case, the second department held that the frustration of purpose.
Well, Your Honor, I was not aware of that, but I'm aware of the Pentagon, which is cited in our papers, Pentagon Federal Credit Union.
Right, and so in Pentagon, we were talking about a partial, wherein the purpose was partially defeated, as opposed to here, where the purpose is totally defeated.
I respectfully disagree that it was fully defeated. If that was the case, Your Honor, then what should have happened in March is, May, Your Honor. The event passed. It is, that date can't be recreated as the papers allege. Their bar mitzvah only occurs once, and there should have been no further engagement to see if the parties could have worked out another date. Instead, if you see the emails that are attached, there seems to be a flow of communication where this is entertained.
So your client wants to keep the deposit based on conversations about things that may potentially could have happened?
No, well, Your Honor, my client wants to keep the deposit because
$27,000.
there was an agreement entered into that
Wait, I'm
said,
sorry, you wants to keep the 27,000?
yes,
And change, it's 27 something.
27 to 1875.
And based on what?
The agreement says it's non-refundable, and there was no force majeure clause in the contract.
And what consideration was there on the part of your client to be able to retain that $27,000?
Well, Your Honor, they gave them the date. That date was marked off for them. They didn't accept any other days on that event. We were within a 60-day period that I believe they entered into this agreement. My client had staff. My client incurred fees and costs to prepare an agreement, to negotiate an agreement. Clearly, there was full intention to proceed.
Could you have provided the venue on May 17?
I do not know that at this time.
So if you could not have provided the venue on May 17, then how is it that you are entitled to keep the $27,000 deposit?
Well, Your Honor, I would say that there are cases within my brief that I cite specifically.
And I'm referring to that K case that says that the purpose of the contract was totally defeated. So if you cannot provide the venue on the 17th,
But we were going to provide it thereafter.
when?
If
We're
he-
now in September and you still haven't provided the venue.
If he provided us, I would say, Your Honor,
Did
unfortunately,
you propose any dates to this plaintiff?
I'm sure there were dates proposed.
Where in the record do we see those dates?
Unfortunately, Your Honor, what I think we have here is there an issue of fact? Okay, so we have email communications that led themselves to believe that there was contemplation of another event date.
Nobody mentioned a date. Did anybody mention a date? Where in the record do we have a date?
There may be an addendum that says a date in the future, either 20 or 2021, to be selected by the parties.
So we don't have a date.
We don't have a specific date.
Okay.
Well, what I have is that on September 13, plaintiff declined to reschedule until the COVID-19 pandemic subsided. So what we can ask plaintiff, but apparently that meant that any date was a date in the future when the pandemic subsided.
And Your Honor, my client would have accommodated that.
Yeah, we didn't know when the pandemic was going to subside. This is 2020. I don't know. I don't recall now. Did it subside in 21 or 2022? Or is it still going on now in 2026?
I would say this, Your Honor, respectfully, the COVID is not the issue. The contract states that you signed a
How is the
non-refundable.
COVID not the issue? The whole reason that the event could not occur on May 17, 2020 was because of COVID and because of the executive order by the governor.
Well, Your Honor, perhaps this is no longer sufficient, but again, I rely on the Pentagon Federal Circuit Credit Union case, which is a First Department case, which says rejected the invocation of the COVID-19 pandemic as grounds for the application of frustration of purpose.
Yes, you have time on me. No, you don't. Thank you.
Thank you.
Your Honours, Robert Garson for Michael Gadd, the plaintiff in this case. Your Honours were nearly excused or saved the possibility of me speaking before yourselves today, and I apologise for it otherwise. Judge Saunders gave a very particularized and very detailed judgment in this case. It wasn't one that was just like, awfully sorry, no. If one looks at page 8 in particular of her reasoning, there's a very detailed reasoning as to what is going on here. And she says, now, in my respectful submission, the appellant loses both on the facts and on the law in this case. And on the facts, because this was a very fact-dependent case, and Your Honor said, well, this is a bar mitzvah. It's a little bit like having, or what appellant would like us to have, is a gender reveal party, maybe in the future, as to what the gender of the baby is going to be. Right? A bar mitzvah is a coming of age. It is crystallized in time. It was there for Johnny Gadd's bar mitzvah on that day, on that weekend. Now, it's very difficult.
The bar mitzvah can't happen on any other day outside of that particular day?
Well, once he's read from the Torah, Your Honor, and once his voice is broken, it comes a bit more difficult when he goes, hey, I'm now a man.
But it wasn't stated in the contract. You didn't. There was no dates that it had to occur on May 17th.
No, but there is a date, and there's no. And this is where Judge Saunders, what she did was she balanced it out. She said, "Look, you've got no force majeure cause in here, and this is your contract, and we're going to construe that strictly against the drafter. And on the other side." We also have an integration clause in this contract. And so what we have here is that you don't have to, unlike Bennett, which is cited in, Malone and Friends papers, which is where somebody had a wedding, it couldn't occur, they then reschedule it once, they then rescheduled it the second time, and then they voluntarily chose at a later date to not go ahead thereafter, that there was a very different sort of state of affairs here. And what the judge in her judgment said is they're not trammeled into the straitjacket of having to accept any other date thereafter, because that's not the way the contract works in these, particular circumstances.
They notified your client on May 19 that they were working on an addendum, and then they notified your client again in July. Oh, excuse me, it was July that they provided your client with the proposed amendment.
And then your client, through the email, seemed to suggest that your client was considering alternative dates.
Sure, and the judge considered that when she looked at what was going on the face of the record. And she said, again, you're not trammeled into that straitjacket of having to accept that because you have the integration clause, that you don't have to accept anything that is not that is not signed by you. The contract is as the contract says. And what's remarkable today, and this is where I respectfully say to my learned friend, it's remarkable. He says, well, yes, they're clearly entitled to certain parts of the money back. We are now standing here today, not a jot has been paid back. There is summary judgment of $52,000 plus 9%, etc., that has been accruing since that point, and never has the appellant turned around to Mr. Gadd and said, "Look, here's half of your money back, the $25,000."
Was that argument made in Supreme Court that you were not entitled to the entire $27,000 whatever.
Yes, well,
Less, that there should have been deductions made, 27,215, there should have been deductions made for staff, vendors, et cetera?
yes, yes, yes. And what Your Honor can see is on the face of the judgment is that the judge stated that they hadn't provided any sufficient evidence as to having to have a standing staff or anything like that.
It's because they couldn't rent the venue because you just couldn't have people congregating at the time.
Correct. It beggars belief. Why would somebody have a standing staff waiting there just in case Governor Cuomo at the time suddenly said, yes, tomorrow you can have a bar mitzvah?
So there was nothing, there was no documentation presented as to how much they paid the standing staff or how much they paid the vendors, et cetera,
Correct.
for the venue?
Correct. It says on page 5 of 6, which would be on page 8 of the record, defendant fails to convince the court that it maintained in-house staff solely for the bar mitzvah celebrations. As defendant was aware, it could not provide the venue on the event date.
Also, how do you respond to your adversary's position that if the May 17th date was so crucial, why did you entertain the discussions about selecting another date?
I can't go into Michael Gadd's mind. He's a very nice man. He might have said, look, let's try and see if we can have some form of celebration maybe in the future.
Well, was this somehow misleading to the defendant?
No, because by that point, so those conversations don't excuse the illegality on the day. Let me give another analogy, and it's not a fire sale one. It's a little bit like the fire marshal closing down the property. It's the same. It's an executive or it's an act of government closing down a property on a certain day. In that day or the day before, if he closes that down, the venue is not allowed to open its property. In those circumstances, is then the venue entitled to withhold a non-refundable deposit? No, they're not in those circumstances. The law is very clear. There's been a frustration of purpose. And I'm very surprised my learned friend doesn't know the case of Kay, which was cited by Your Honor, because it's there slap bang in the center of our briefs. And he should be there to address it.
Thank you very much. Thank you both. Simeon versus the City of New York.
Good afternoon. My name is Paul Golden, and I represent designer of fragrances DBA Kiehl's. A landlord prepares lease, landlord and tenant shake hands on it. The landlord is responsible for structure. Tenant is responsible for non-structural issues. They could have made it a different deal, but that's the way the landlord wanted it, and presumably the rent is adjusted accordingly when the landlord takes on the responsibility of the structure. The landlord has a legal obligation beyond the contract, has a legal obligation to make sure that they periodically inspect the sidewalk and make sure that there's no structural defects and nothing that would cause somebody to trip and fall. But that's not what happened here. For whatever reason, the landlord did not do that. There was a slow motion adjustment of a sidewalk flag. It eventually became out of alignment enough that someone tripped over it. It's when something happens in slow motion like that, it's bound to happen at one point, one or
What about
another.
the patch? Wasn't there a patch at some point in time that was apparently removed?
There's no evidence that there was a patch. People were asked about it. They looked at a photograph of it, and they all said, no, that does not look like a patch to me. But even if there was a patch there, that doesn't mean that the tenant has the obligation to maintain the patch, keep the patch there. Whoever put it there in the first place does not have to keep it there.
So what do we do about the lease agreement, which states that you are to indemnify defendants for all liabilities, suits, obligations, fines, damages asserted against landlord by reason of any tenant's use, non-use, possession, occupation, condition of the demised premises occurring during the term of this lease, of the demised premises or part thereof, or of any sidewalk or space comprising a part of the building or demised premises or adjacent thereto. Would seem that under the lease agreement, you would be responsible for the sidewalk.
But the more critical part of that lease indicates that we cannot and we're not permitted to make structural adjustments. It says that the very specific clause in there says, no, the tenant does not handle structural issues. And
How did
case
we get
after
to
case-
structural issues? Was that, is the contention that this was a structural issue?
Yes, it's a structural issue. It's not only that it's a contention, it's a structural issue, but case after case from.
Who stated that it was a structural issue?
Sorry, who
Who
says this?
stated that it was a structural issue?
Because the plaintiff said there was a 2-inch gap between the two
So
sidewalks.
your argument is that it's a structural issue.
That's right.
And did you present an expert or someone else who stated that it was a structural issue?
The issue of whether it's, no, the issue of whether it's a structural or non-structural issue is one of law.
How is it one of law?
Because case after case have indicated that any issue concerning repairs that need to be done to sidewalks, that is in of itself a structural issue.
Regardless of the nature of the repair?
Yes, I mean, unless it's something along the lines of.
What case says that?
Well, one case would be like the Maman case.
And this is regardless of the nature of the defect, right?
Yeah, any kind of defect in a sidewalk is a structural defect. That's right. It is a structural issue. But we don't have to, but of course, we don't have to parse terms here and get into, if there's ever possibly, there might be a case in which some issue for a sidewalk might be non-structural.
I thought
Counsel, let me say that
Go ahead.
allegedly we disagree with you with that. So can you just answer what evidence you provided to show that you didn't create, your client didn't create the alleged defect?
It's indicated.
Assuming we disagree that it's not,
It's
structural.
indicated in the record.
Where?
That I'd have to find it, but that this was caused, that a root, the roots kept moving and moving. And
Is that established, or is that something that was suggested?
I believe one of the adversaries indicated that that's what happened here. But it's because of the nature of what it is, if we could because of the nature of what a sidewalk is, it's not something a tenant can do. A tenant doesn't start pulling at sidewalks. When sidewalks have a sidewalk flag misalignment, it's not something the tenant could have done.
I thought that was your argument, was that the sidewalk was not a part of the premises as per the lease agreement. I thought that's what I read in your papers.
That's also true, but
I did not see anything in your papers concerning a structural defect, which by law you have no right, no obligation to repair. But you have time on rebuttal.
Okay, thank you. That's in the lease, and it's referred to in my brief.
Thank you.
May it please the court, Jack Watkins from Kahanafeld for the respondent, Dallin Management. I want to take that point up directly. I think that even if there were an argument to be made that there's by law no ability for the tenant to repair a structural defect, and I think my friend overstates that because the lease actually says the tenant must repair structural defects provided that the tenant caused them. So therefore, there is no prohibition, absolute, on doing structural repairs. I think that what's more important is that the lease also says that the tenant has a duty to maintain the premises, including the adjoining sidewalks, in good working order, and additionally contemplates, and this is also the, I think it's the Putnam v. Stout case that's cited in our brief, that contemplates going to the owner when you have a defect. There is no record, not one record whatsoever in this here, no evidence at all, that at any point the tenant said, there's a structural defect here, owner, and it's your obligation under the lease.
Right. I thought that the issue was that they were attacking or stating that they had no obligation to indemnify you based upon the fact that under the lease agreement, they were not responsible for this area, and that they stated that the sidewalk was not a part of the premise, of the premises, yes, as contemplated in the lease agreement.
Yeah, they do make that argument. They make a couple of arguments on that point. They make, especially in the reply, they sort of a rundown of their indemnity arguments. But one of their arguments is, these aren't the premises we rented, which I don't see how that helps them at all, because everywhere, all throughout the lease, it says the premises and the adjoining areas, including the sidewalks. But I think that a lot of this puts the cart before the horse, and I can't help, even just now listening to the argument, there's sort of an assumption that there was a defect.
Right.
But plaintiff hasn't moved for summary judgment. The
Yes,
jury
because we're
could-
talking about indemnification, yes.
We're talking about indemnification. There's
In
been
the
no
event that
finding.
there is a finding that there was a defect.
Right, so he's saying not only will there be a defect, but you will be found negligent, and it will be a structural defect, and it'll be found that we weren't negligent at all. All of this is baked in, it's assumed. Nothing in the moving papers below eliminated questions of fact as to any of those points. In fact, it left them wide open. And many places in the reply brief, especially, I think you'll find, it treats it like we're the movant. And while we did cross-move below, and I understand that that's the record, we didn't perfect our appeal. We're respondents here. The question is whether
And also, I will note that Supreme Court stated in their decision that they did not, that Kels did not meet its prima facie burden, and there's a material fact as to who created the condition and whether it is structural or non-structural.
Correct. If there are no further questions, I rest on my brief.
Thank you.
As I understand the decision below, the question of whether it's structural or non-structural is a legal question as to whether, when something has a 2-inch gap and when someone says they've tripped over something with a 2-inch gap, whether the court can consider that as structural versus a non-structural.
No, the court stated that there's a material fact as to whether it was structural or non-structural. That would have to be determined first, would it not, before any issue as to indemnification?
No, because there was no real dispute about that there was a 2-inch gap. The question, as I understand what the court was trying to say, was that once there's a 2-inch gap, then we have to decide, is this a structural issue or a non-structural issue? Partially because of the patching that may or may not have existed.
Okay, and then if it's a structural, then who would be responsible? And if it's non-structural, then who would be responsible? Those are questions that would have to be determined.
No, but these are, once we accept the fact that there's a 2-inch gap and the person said that they tripped over a 2-inch gap, then we don't have to, the issue about whether this is structural or non-structural is one of law. And what I understood the court was trying to get at was that that the court believed there may have been patching at one point, and believed that, well, if there's patching there, or there could have been patching there, that makes it non-structural. That seemed to be what the court was trying to say.
Well, that's not what the court actually stated in its decision. The court states that there's a question of fact as to whether it's structural or non-structural.
I understand that, but the court didn't explain further than that. Since there was no dispute that there was a 2-inch gap, that the problem, what the plaintiff was complaining about, was the sidewalk itself, then that led to no other conclusion than this is a structural issue, which is one of law, not fact. I don't believe the court was saying, I'm not sure if it was a 1/4 inch or if it was an 1/8 inch or otherwise. The court wasn't saying that. The court was just. I just want to say one more thing is that there's no evidence.
But you cannot because your time is up, but thank you anyhow.
Thank you so much.
Shanklin v. Wilhelmina Models, Inc.
How you doing?
Yes, you may proceed.
Thank you, Your Honor. May it please the court, I'm Joseph Devanzo for the defendant appellant Next Management LLC. I'm here with Pauline McTiernan of the Otterberg firm for the defendants appellants, the Wilhelminas. Judge, 1,634 days after Justice Sherwood granted plaintiffs leave to form classes, 2 classes in this action, the plaintiffs finally sent to defendants a proposed order to form those classes. Justice Sherwood had directed the plaintiffs to e-file a proposed order after there was a meet and confer with the defendants to agree, if possible, on the form of that order, which would describe those classes. That order by Justice Sherwood contained a statement to the effect that the plaintiffs needed to settle the order on notice.
Where did it state that?
It doesn't, Judge. What it
Oh.
says is, it says, you shall e-file. Now, in NYSIF, when you e-file, you are submitting something to the court, and it automatically
Aren't
provides.
there boxes which state either settle order or submit order?
Yes, there are, Judge.
On this form, was either box checked off?
No, Judge. But that had nothing to do with the decision. The decision granted leave to form classes. In that decision and order, there was an additional step that needed to be taken, which was for the plaintiffs to meet and confer with the defendants, to come up with the form of that order, and then to submit it through NYSIF, which would have given notice once they filed it. And if we hadn't agreed, we would have been able to put in a counter order. This court decided just in March of last year in WV Partners versus Hudson Private that the court looks to see whether or not there is a statement to the effect of submitting or settling an order on notice. And I say to you that when Justice Sherwood said, e-file a proposed order after meeting and conferring with the defendants, that is the same. It is a statement to the effect that there should be an order submitted to settle this on notice.
So again, the fact that the box is on the form, which would actually give notice as to what you're supposed to do, the fact that neither box was checked off is of no consequence?
No, Your Honor, because it's a box
So why do we have the
checking
boxes? Why do we have the boxes on the form?
Well, that's the old days. When I used to be a clerk for Judge Baer in New York County, those were very important. But once we got into the new age of the e-filing system, things changed.
And is there anything, any case law, any cases, anything that state that we no longer check off the boxes?
Not particularly, however, but the Court of Appeals in Funk v. Vary said that the real issue here is whether or not the court needed further assistance by counsel.
Counsel, have the parties during the course of the litigation been conducting themselves as though the classes were not certified?
What we did was, once that motion was decided, then we focused on merits discovery. And from the defendant's...
So you've been operating as though the classes were
No, Your
certified by engaging in mediation and other actions?
The mediation, first of all, did not suspend their obligation to present an order, Judge.
But you did conduct there was mediation conducted, there was discovery on the class issues, there was correspondence, so things have been occurring during this period.
Well, the litigation was moving forward, but the class discovery took place before the class certification motion. Afterwards, the defendants were focused on the discovery of the merits of the individual plaintiffs. In my case, it was one class representative and then another that was added much later in June of 2024. However, the court has said, the Court of Appeals has said that 202.48 applies when the court requires the assistance of counsel. And here, the court required that because the class that was certified was very different than the one that the plaintiffs originally defined. And
So has there been, I'm sorry,
ahead.
go ahead. Has there been any prejudice to you by this delay in the class certification order being settled?
see, the thing here is that there had to be a showing of good cause for the delay. And just because there's an absence of prejudice doesn't mean that good cause has been established.
You mentioned the class certification. Was there anything during this period of time which would lead you to believe that plaintiffs had abandoned the class action status?
Yes, 1,634 days passed before they decided.
Other than the passage of time, was there anything in terms of conduct, in terms of discovery, mediation, et cetera, which would lead you to believe that there was any abandonment of the class certification status?
Well, 1 year after the class certification motion was decided, the plaintiffs submitted a status report to the court in which they described the case as a putative class action. So they weren't even talking about it in terms of it being a class action a year after the motion had been decided.
Counsel, you know, what weight should we give to the fact that your client repeatedly stated in pleadings and correspondence with the court that the classes have been certified? And I'll take you to the pages, the supplemental record 22, 26, and 95, where repeatedly stated the classes have been certified. So what weight should we give that?
Well, Your Honor, there was a motion that was decided that granted leave to form the classes. That is correct. However, just because you don't use the word putative in front of class action when you're talking about a class action versus a trip and fall or a hit in the rear doesn't necessarily mean that the defendants in some way conceded that the classes had been formed. They had not. And we cannot waive the requirement of 202.48. Thank you, Your Honor.
Yes, you do have time on rebuttal.
Good afternoon, Your Honor. David Cooper for the plaintiff's respondents. The Supreme Court granted plaintiff's motion for class certification in 2020, and over the next 4 years, the plaintiffs, the defendants, and the court expended enormous time and effort and resources litigating this as a class case.
So is there any significance to the fact that neither box was checked on the form?
Yes, there is. So in the Funk v. Barry case, what the New York Court of Appeals said is it has to be explicit. That's the exact word from the decision, explicit, that the order has to be submitted or settled or submitted on notice. And that's the reason for the boxes, because Rule 202.48 is not intended to be a trap for the unwary. It's supposed to be very clear. Either the court says, by checking those boxes, that it's submitted on notice or settled, or it does not. And here, those boxes were unchecked. And not only were those boxes unchecked, that was the only place throughout the entire order that those words, submitted or settled, were in the order at all. And so, far from being explicit, there was a clear indication that the court did not consider this to be a requirement of being submitted on notice or settled. And there is no case that we are aware of, certainly no case that defendants have cited, where a court has said that Rule 202.48 is properly invoked, where there is no explicit statement that the order is to be submitted on notice or settled.
So the statement by the court that counsel is to e-file a proposed order certifying classes as authorized after counsel have met and conferred to attempt to agree on the form of said order. As counsel argued, wouldn't that be a statement to the extent that you're to submit or settle an order?
No, not within the meaning of Rule 202.48. So I think that is really the meaning of the holding of Funk v. Barry, which is we're not going to have the parties guess at whether something means submitted on notice or settled. It's a requirement for it to be explicit. Now, of course, that doesn't mean that there's nothing required of the parties. The parties at some point certainly did have to e-file a proposed order. The question is, was there a 60-day requirement to do so within the Rule 202.48?
Was there ever an order e-filed?
Yes. So ultimately, after the 4+ years, there was an order, a proposed order filed, which was ultimately adopted by the court as to the definition of the class, and a class notice which was issued to the class in early 2025. So this case can be affirmed on that ground alone, and the Supreme Court actually did not reach that ground because it also found, even assuming arguendo that Rule 202.48 applied, that there was good cause to excuse and to not deem the action to be abandoned. And what defendants say here is that they believed that it was abandoned. But if they believed it was abandoned, why would they have waited 4 years to raise that to the court? It doesn't make any sense. But even further, certainly—
Was there anything done during that period of time in terms of class certification? We mentioned the mediation, but was there anything else done in terms of discovery as to the class?
Yes, so there was a mediation for, I believe, approximately a year and a half. And after that time, there was extensive discovery to the point where there were monthly conferences with the court giving status updates on discovery. There was enormous discovery going back and forth. There were expert reports. At this point, now we have summary judgment fully briefed. So yes, there was an enormous amount of work on, there was expert reports as well and motions on expert reports. So there was an enormous amount of work on both sides and for the court as well, treating this clearly as class claims. And I point this court specifically. They said that they were purported class claims, but that's not actually what the record shows. What the record shows, and this is page SR 22 to 23, a joint status letter saying the court certified a class against Next. August 13th of 2024, this is SR 95, their own answer, the court certified a Wilhelmina class. So there was no dispute about the parties' understanding that this was a class case. They proceeded on that basis, expended enormous effort to do so, and to deem this abandoned and prejudice the rights of literally thousands of class members would not make sense, and certainly it was not an abuse of discretion for the Supreme Court to say so. If the court has no further questions, we'll rest on the briefs and ask this court to affirm.
Thank you.
Thank you.
Judge, just briefly, touching on what my colleague said, as far as explicit, this court decided in WV Partners LLC versus Hudson Private Corp. In March of 2025 that you look to see whether or not there was, quote, a statement to the effect, unquote, of a submission of an order or to settle an order. So the box-checking exercise of elevating form over substance does not do justice to what Justice Sherwood ordered the plaintiffs to do, and that was to submit a proposed order on notice after trying to settle the language with the defendants. And they took too much time to do that, and so they abandoned it. Their own status report in SR 20 describes the case as a putative class action. In addition, good cause was never shown here. There's a two-part test, and that is you have to show good cause for the delay, and there's never been a showing of good cause for
Why
the
would
delay.
the good cause not be the fact that the boxes were not checked off and therefore they were unaware of that they were to settle order or to submit a?
Well, first, there's no affirmation by either of the attorneys that put in affirmations in response to our order to show cause to vacate the order, saying that they were confused, that they misunderstood, that they reached out to the court to understand what to do. As soon as they realized that the order had not been settled with the defendants, they immediately emailed a copy to the defendants and asked for a meet and confer. So they knew exactly what had to be done. They understood the direction of the court. The fact that there's no box checked, that does not do service to the Court of Appeals ruling in Funk v. Barry, which says—
And it has to be explicit. How do we characterize it? How do you characterize Justice Sherwood's statements as explicit?
But this court in WV Partners didn't say that it has to be explicit. It said there has to be a statement to the effect, and that's consistent with the Court of Appeals decision in Funk v. Barry, which says, look to see whether or not the judge needs the input of counsel, because it's a complex issue. And here it was, because we had to redefine the class, because now that there was only 2 labor law claims that were in the case as class claims, we had to limit the class to only those models who did work in New York, consistent with the Lady Gaga case. Thank you very much.
Flores v. New York City Health and Hospitals.
Good afternoon, Your Honors. Catherine Herr-Solomon on behalf of the defendant, New York City Health and Hospital Corporation. The plaintiff's experts' opinions were insufficient to support the liability finding in this case. The experts' opinions were not supported by the facts in the record, and they failed to reconcile the facts in the record with those opinions.
So the CT scans, which according to, I believe is Dr.
Alpert.
Right. Harper says that he saw air in the CT scans, which mean to him that there was a microscopic hole in the esophagus,
Right.
causing air to be in a place where it shouldn't have been. And then following that up by Dr. Kumjian that says there was this microscopic tear in the esophagus, there was air there, and then that subsequently turned into a quarter-size hole, which is what caused the September 22nd incident.
Right. Those opinions were tailored to reach a desired result because they.
Did the CT scan show that there was air where air should not have been?
Well, the defense experts and all of the treating physicians who viewed the CT scan said that there was no air there.
But the plaintiff's expert said that there was.
Right.
So what you have is an issue of fact for the jury to determine, don't you?
No, because.
Let me ask you this question, because I believe Dr. Haber was shown, I don't remember the number, but it was more than your expert. I think it was just 4, am I correct?
I believe so.
All right.
4 or 5.
How many for Dr. Haber? How many? Because it was more than 4. How many?
I'm not clear on the number, but I know that the doctor who interpreted the CT scan, he testified at trial, and he clearly looked at all of the images of the CT scan. But getting back to.
Because I want to go back, because I was under the impression that whatever the number was that Dr. Haber, reviewed, I was under the impression that there was no testimony that contradicted the other photos. And also, your expert even conceded that black spots indicated air.
Right, but the reason that those opinions are not supported by the record is because the evidence here of the decedent's condition was completely inconsistent with a finding of a fistula and mediastinitis.
Counsel, how can you say that when the hospital's own records indicated that a CT with blue dye should be done to rule out the presence of a fistula? And that was which was common in this type of procedure.
Okay.
And I thought on September 22, he was diagnosed with a fistula.
That's on the 22nd, but plaintiff's theory is that he should have been diagnosed on the 14th. And
right, and in your records, early in his admission, that's when your records indicate that this test should have been done.
Well, the test was done. It was done with.
Was it a CT with dye?
It was with dye through the veins. It wasn't an oral dye. So
but the notation in your record said blue dye, right? That blue dye notation of the type of testing that should be done to rule out the fistula was not done.
Right, except that the facts of the case do not support that there was a fistula on September 14th and he continued to improve his white blood cell count.
I don't understand how you could say he continued to improve.
All of his vitals were stable. There were numerous notes that his pain improved. His white blood cell count went down. And I'd like to point the court to.
Well, during this period of time, he was medicated with a number of medications, including steroids, right?
Right. I'd like to point the court, though, to the plaintiff's own expert's testimony, Dr. Haber, at page 506. He's talking about the September 14th CT scan. He's saying that it shows mediastinitis. He's saying that the esophageal contents are now freely moving around in this otherwise sterile environment. But yet this plaintiff was able to eat and drink for the entire week.
But not entirely, because he was complaining that he could not eat all his food because.
You're talking about the week of the 17th, September 17th?
I don't recall the plaintiff.
Well, because during that period of time, he's complaining, he's stating that he cannot eat all his food. He's also complaining of chest pain and he is refusing food, if that's the week that you're referring to. But counsel, let's go back. I'm not understanding how you can say you have experts who make certain opinions or give certain opinions. You have other experts who state other things, and then you have the record. How can you say that that these are not questions of fact for the jury to determine, and that the jury did not make a determination based upon what it was presented with?
Well, it's based on the cases from this court where in Rivera, the clinical findings one would expect to see in a patient, in this case, with a fistula or mediastinitis, were not here. The plaintiff's own expert conceded he did not know that the decedent's fever subsided during the admission. He was unaware of the chart entries that noted that the decedent's pain had improved. He did not know, I mean, there are numerous notes in this chart that the decedent ate 3 meals a day.
Is there any evidence that he should not have, presented from your witnesses, that he should not have been able to eat at all?
Yes. I mean, the defense experts testified that if he had a fistula and mediastinitis on September 14th, as plaintiff's experts claimed, he would have required ICU. He would have been septic. He wouldn't have been able to eat. He would have been tachycardic. His blood pressure would have been low. That was not this
Is there any explanation
situation.
from your witnesses as to why you didn't follow your own recommendation to have a CT scan with dye?
I'm not certain why that CT scan, it was with dye, as I said, through the veins, not orally. I don't think it's clear from the record why the initial CT scan was not with that dye, but
it is clear that it was without the dye, although it was indicated that it should be with dye.
I'm not even sure that it was indicated that it should be with dye on the 14th. If he had failed to improve, they would have certainly done another CT scan, but he was improving.
So you're stating he comes in on the 14th, and it's after September 21 that the fistula is finally diagnosed. You're saying that somehow this developed during the period of time that he was being hospitalized?
Right.
In fact, it was your witness's testimony that the fistula spontaneously developed on the 22nd.
Well, there was...
How's that not speculation?
There was testimony from numerous of the treaters, and they agreed that it was either not September 20th, September 21st, and then it was definitively diagnosed on the 20th.
Well, how does it just manifest in September? September 21 or September 22 when he's doing so well, according to...
It's something that develops following an ablation, and it wasn't diagnosable on September 1st.
But counsel, there's a September 14th note from a cardiologist that was attending that indicated that a CT scan with IV contrasting was recommended to assess for fistula. And that's your own records. And that's September 14th.
And it was administered with IV contrast through the veins. And plaintiff is alleging that it should have been oral contrast. There's no note in the record that an order for oral contrast was entered.
Is there a reason why one is done and not the other? Is it not because of the symptoms that he presented? It should have been oral as opposed to through the veins?
His symptoms were consistent with pericarditis. Plaintiff's own expert conceded that he also suffered from pericarditis. So there was no basis to order another test unless he failed to improve, which happened on September 21st and September 22nd.
Going back to his ability to be able to eat, if he had a microscopic tear in the esophagus, as testified to by Dr. Haber, that it was a microscopic tear that he had there, would that have prevented him from being able to eat?
Well, Dr. Haber goes from calling it microscopic to calling it a tear. And that's I just quoted his testimony. He is saying that the esophageal contents are now freely moving around in this otherwise sterile environment. That is the identical testimony of the defense expert to demonstrate that that could not have been happening on September 14th because the decedent was walking around. His vitals were normal. He was eating and drinking.
Isn't there information in the record that by September 15th he was found sitting on his bed, moaning in pain and unable to lie on his back. And that's September 15th, the next day.
Right, so that is a symptom of pericarditis, as it was explained by one of the experts in this case. When the patient lays back, the heart is leaning up against the inflamed area, which causes severe pain, which is why when he was sitting forward, he was not in significant pain.
You have time on rebuttal?
Thank you.
Yes, you may proceed.
Good afternoon. My name is Stuart Diamond. I'm here on behalf of the plaintiff respondent appellant. So I don't forget, Justice Kennedy, in response to your question, their expert was shown 4 images during trial testimony. Our expert testified about 9 images on the PowerPoint display. So as to 5 images, his testimony about the air leaving the esophagus and being in the mediastinum was essentially unrebutted. Briefly, we have an initial procedural argument. Their post-trial motion omitted all 7 of the family witnesses' testimony, which were relevant both to damages and liability issues, not only on trial, but on this appeal. So for that reason alone, those branches of their motion should be denied, of their appeal should be denied. And this was raised in opposition to the post-trial motion. On the merits, as is pointed out, there was this 914 note from the emergency room treatment. Patient needs immediate CAT scan to rule out life-threatening atrioesophageal fistula.
But it doesn't state whether the dye should be, whether it should be, or how it should be administered.
Correct. But that was addressed at trial. Our expert testified and explained why the swallow was necessary, because that's the way, graphically, they could track the extrusion of the dye from the esophagus and see exactly where the hole was.
And to be clear, he came in, his initial complaint when he went to the hospital was chest pains. Is that correct?
That's why he was there. And not only did our expert testify to that, but somewhat reluctantly, their medical witnesses and their medical experts agreed, at least, that it would have been helpful.
So
both sides were. I'm sorry.
They state that September 14, September 15, there's no indication of fistula, and that it just happened. It just occurs September 21 or September 22. Did you present any evidence in terms of your experts, et cetera, as to how that would not be possible?
Well, first of all, there's on September 14th, the doctor in the emergency department suspected the atrioesophageal fistula right away. There was testimony, their argument that he had 6 days where he was getting better and better.
Right, he was, according to them, he was eating, he was taking nourishment.
They cherry-picked items from the record, and as we pointed out, in the record itself and in the autopsy report, he was complaining, he had worsening mid-epigastric pain between September 15th and the 21st. A rapid response team was called on the 18th because of a rapid heartbeat. He was crying and complaining of chest pain on September 18th. Plus, there was all the testimony from the family, the testimony that was admitted from the motion, particularly his brother Domingo, who testified that he was in terrible condition. He was complaining every day, couldn't swallow pills, he was getting worse, he was screaming all the time, he couldn't eat. This was during that first week, not after everything started collapsing. That was during the first week. So there was evidence not only from the hospital chart, but from a witness who was there. He testified every single day during the first week he was treated, and he specifically saw him on 4 of those days. He said some of those days he was there the entire day. That omitted testimony, which is now in the record, specifically addressed their argument, at least for the purposes of leaving it up to the jury.
So he came into the hospital in September 14, and he died on around November 8? No, excuse me, November 16.
Yes.
During that period of time, how many surgical procedures were performed?
We counted about 25 surgeries that were performed, surgical procedures that were performed, multiple amputations of his leg, eventually up to his groin, constant changes of with the heart mechanism that had to be installed. He had open wounds. He had open wounds with.
He had debridements?
I'm sorry? He had
wound
multiple debridements.
Feeding tube?
Feeding tube, he was breathing through air. This is based upon, the best place to see it is in the autopsy report, which we cited the language specifically, but also now we have 7 family members who testified as to the extent of his damages once the diagnosis was finally made. And the difference, even the day before or 2 days before, is very relevant in this case because this whole panoply of disastrous results resulted from a tear of the aorta, which was dependent upon timing. So even if it was just a day or two before that some of these complaints were made or observed by family members, that's relevant to his damages, particularly his catastrophic damages.
Thank you.
So as to the plaintiff's argument that the appeal should be dismissed, plaintiff never argued before the trial court that the post-trial motion was defective, so it's improperly raised for the first time on appeal. The majority of the transcript was attached to the post-trial motion, and it was decided by.
Counsel, can you go to the issue of the award here and what cases you rely on to say that the award of the jury was outside of the realm of where it should be?
So it was reduced by the trial court to $4 million. It's a 2-month period of pain.
Well, the jury came back with 6.1, right?
Yeah. Well, plaintiff doesn't cite any cases that would support a $4 million award for past pain and suffering.
Because I guess plaintiff wants a 6.1.
Well, he doesn't cite any cases that support a $6.1 million award either.
Well, I was asking about your cases.
Right. The cases, small is several weeks of pain and suffering prior to death, and that was a
Several weeks, so we're doing it by timing of how long?
Oh, that's one of the relevant elements in deciding whether.
It's not the only one, is it?
No, not at all. And small involved a patient who died of multi-organ failure, gastrointestinal hemorrhage.
Any cases that you're citing from that deal with all of these hosts of multiple medical procedures that the patient had to undergo?
It's not clear from these decisions if they had any surgical procedures. I doubt that there's one out there that's an.
So do you think that this case with all of the multiple surgical procedures takes it outside of the realm of the cases that you cited to?
I don't believe so. I mean, it was a tragic circumstance, but the patient was received medication, pain medication, was not conscious for much of the time, particularly during the surgical procedures. So,
well, he was obviously in pain for a significant period of time. He was moaning. There was procedures that were being conducted that were painful.
Right, but he was anesthetized during those procedures. And
what about when he slid off the operating table?
So he slid on the operating table. He did not hit the floor, and that allegation should not have gone to the jury because plaintiff's expert never causally connected that to any injury.
What about the amputations?
The
amputations.
As far as connected to the slide off the table?
Yeah, no, just in general, in terms of the award.
Right. Well, some of the cases that are cited in our brief have plaintiffs who suffered amputations, and the awards.
Right. Do you have any case that has a plaintiff that suffered amputation, that suffered 25 medical procedures, that suffered all that in combination?
No, but I.
So you agree then that what happened here is rather unique?
Yes, it's unique, but the court still has to. I mean, there are cases that are somewhat analogous.
Right. And you do the best that you can with the cases that you have. But if you have nothing that's on point, how can one make the argument that it should have been reduced to a specific number? There's some leeway, in other words.
There is some leeway, but in order to maintain the court's duty in assessing damages.
On what, on cases that are not comparable or on cases that are comparable?
Comparable, and there are cases that are cited that are comparable despite the fact that they didn't involve this
They're
many.
comparable if you're picking apart the injuries and isolating them. So if you pick apart, they're amputation cases, they're cases where the pain and suffering was for X amount of days, but I have yet to find one that involves the disastrous events that happened here.
Well, there's these cases.
What's your closest case?
I would say the small case, although it's not clear from the facts of the case whether the patient had surgeries. The Stewart case,
You said small?
yes. In Stewart, the patient suffered a rupturing of the lining of the brain.
28 days, he was improperly discharged, although suffering from acute bacterial meningitis.
Right. And
Small deals with, that was a multi-organ failure,
right.
but we have no information about multiple surgical procedures.
Right, but I would say that, as I said, we are comparing patients who suffered prior to death for a certain period of time. He was anesthetized during the surgical procedures and received significant pain medication. So that
Was he also anesthetized whenever they had to do the debridements?
I believe so, yes.
So is it your position that because he was anesthetized while he was having the surgical procedures, that there was no pain and suffering once he woke up from the procedure?
I think the record establishes that he was unconscious for most of this, the admission following that September 22nd surgery.
We have a video in the record of him being conscious.
The way he's moaning, right? He's
Yeah.
crying for help.
Right.
Thank you. Yes.
I'm only going to use a few seconds of my 2 minutes. I won't go through the litany of.
Well, the same question for you, counsel. Do we have any cases that you are aware of which would substantiate such a verdict?
There are no cases similar to this in terms of the unusual circumstances of the multiple injuries. We did cite 2 cases. If the implication was we didn't cite any cases near $6.1 million, we did. We cited 2 cases, present-day value of over $5 million. He was on fentanyl during the last few days that he was in the hospital. That's how much pain he was in, had to be treated. And on the issue of conscious pain and suffering, the day before he died, a note from that day states, November 15th, he was awake and arousable and following commands. There was also the video, there was a photo, I think was also from the day before he died, and there was all that family testimony about the significant, substantial pain and suffering. Thank you.
Thank you. Coronel v. Markel Contracting. Yes, proceed.
Good afternoon, Your Honors. May it please the court. For the appellant, Markel Contracting. Your Honors, this appeal presents 3 discrete legal errors here. The Supreme Court erred in imposing Section Labor Law 200 liability on Markel Contracting when there is no disputed evidence that Markel controlled, supervised, directed the injury-producing work. Your Honors, this is not a premises condition case. This is a case where there was a concrete form that was mounted on the wall and that was inadequately done. And this is a perfect means and method condition that directly arises in the manner in which the work is performed.
Who directed the employees' work?
It was Capital Concrete, Your Honors, and that is backed up by the contractual obligation in the subcontract agreement between Markel and Capital Concrete, and it is also backed up by the testimonial evidence.
The plaintiff testified that he received all communication from his foreman and no communications with your client. or
Yes,
your
Your
client's
Honor.
employees.
Yes, Your Honor, that is correct. And in fact, the Supreme Court here overlooked the operative provisions of the contract that says on paragraph 1 of the subcontract agreement that expressly provides capital to provide all the labor, layout, supervision, material, direction, control, everything by capital.
And your client had no responsibility for the premises.
Yes, Your Honor, that's correct. And in fact,
And plaintiff also testified that Capital provided and performed the work as related to the concrete form.
yes, Your Honor, yes. And in fact, in item 20 of the scope of work, it very specifically states that this subcontractor shall furnish and install all the equipments.
Capital.
Yes, Your Honor.
Thank you.
Your Honor, the second.
I think you had time on rebuttal. Thank you.
Yes, Your Honor. I want to continue on the second.
You can do so on rebuttal. You did have rebuttal.
Yes, Your Honor, but with regard to my indemnification, I just want to mention.
Yes, go ahead.
Okay, so here the Supreme Court once again erred in denying contractual indemnification despite clear and broad enforceable indemnity language and complete absence by Markel contracting, Your Honor. Thus, once again, the Supreme Court overlooked the subcontract agreement that provided clear indemnification language, Your Honor, that Capital expressly agreed to defend, indemnify, and hold harmless Markel to the fullest extent permitted by law. And Your Honor,
you would be entitled to indemnification from Capital, yes?
Yes, Your Honor.
Okay, thank you.
Good afternoon, Your Honors. May it please the Court, Shanna Bailey of Fuchs Rosenzweig for the third-party defendant, respondent, appellant, Capital Concrete. Your Honor, I believe that the appellate's counsel didn't address one of the arguments, which was the court's granting of plaintiff's labor law section 241 claim. So if it would please the court, I will take just a couple of moments to touch upon the arguments that were made in both of the appellant's briefs. We don't know how this accident occurred. There are multiple inconsistencies in plaintiff's account. In one account, he's standing on a ladder open to the sky and a beam falls from somewhere, somehow on him. In another account, he's standing on the floor and he's handing up a form to somebody and there is no open to the sky, there's a ceiling and the beam somehow falls and lands on him. Somehow this is completely unwitnessed, even though...
But in both accounts of the incident, whether he's standing on the ladder or standing on the floor, he's consistent with one thing: a beam falls on him.
Well, there is consistencies when it comes to that. However, it's an unwitnessed accident. And
So does case law consider that is witnessed or unwitnessed?
yes, it does, Your Honor. And in multiple cases that were cited within both of the briefs, the First Department has clearly held that where the plaintiff is a sole witness and his credibility is called into question.
Where is his credibility called into question?
Because, Your Honor, he gives multiple, well, first of all, he gives multiple versions of this account. Was he on a ladder or was he not? Was he wearing a harness? Was he not?
It doesn't matter because, again, what he's stating is that it's what caused the injury was the concrete falling on his head.
But it fell allegedly from a head when it's open to the sky. So how did it fall if there's no ceiling there, Your Honor, and land on his head? Additionally, when he first reported the accident, the only time he reported the accident, he reported it not to his own foreman, despite there being multiple people from Capital Concrete admittedly on the site. He says he fell. There's no reference whatsoever to a beam struck him. He says that he fell. Days later, when his foreman texts him, he says, I hope you recover from your illness, because it's well documented that in the days leading up, he had specifically said that he suffered from vertigo, dizziness, and in fact had been instructed repeatedly not to work from a height. So there's
Counsel, how do you distinguish this case from a case cited by the plaintiff, Veriu?
Very you, because Your Honor, again, in this case, we have the plaintiff's credibility is totally called into question here. He's inconsistent in every step of the way. The court and the parties don't know exactly how this happened. Where did this beam allegedly come from if it's open to the sky? Did he fall off of a ladder? Because the lower courts did this as just a falling beam case. However, his testimony is that his injuries arose in part because he fell off of a ladder. He doesn't, there's inconsistencies in how he reports it. Is it that he fell with no reference to a ladder or a beam? Is it because he was struck only by a beam? And then just to quickly wrap up, going to section 241.6, Your Honor, the only provision undisputably that's at issue is a material and equipment being stored on a floor, platform, or scaffold. Under any account, Your Honor, allegedly this beam is a component of the wall. It's not material being stored. It's material that's alleged by plaintiff to be in active use as a part of a wall. It's not stored on a floor. It's not stored on a platform. It's not stored on a scaffold. Where it fell from, again, is completely inconsistent, but it allegedly falls from somewhere, but not from a floor, a edge, or a scaffold. And so therefore, the first department, the fourth department, the third department, the second department have all held that by the plain language that this would be inapplicable, the industrial code provision would be inapplicable. The last thing I will address is as to the indemnification. We believe that the lower court did properly find that there were questions of fact as to how the accident occurred, such that we can't say that it arose out of Capital's work. The plaintiff doesn't know who installed this beam. He doesn't know when it was installed. We don't know why it fell.
Isn't that the scope of work, putting up, because they're concrete contractor?
We were correct, Your Honor, yes. But when plaintiff was asked, because he had testified that he was working in that area in the days prior, he said that there was different groups of workers that were coming in and out that were performing this work.
Well, we do know that Markel had nothing to do with it, right?
Markel was not the concrete subcontractor. That is correct, Your Honor.
Thank you.
Thank you.
Good afternoon. May it please the court. Vincent Chirico. I think Your Honor has it right. I think this is Virouette on all fours. In Virouette, pins were missing from the concrete form that fell. Here, pins were missing from the concrete form that fell. This isn't a case where, as counsel would indicate, we don't know how it fell, from where it fell. Number one, it fell. Number two,
Was the plaintiff's testimony somewhat inconsistent in terms of whether it was open or closed, in terms of the...
It may have been, Your Honor, but whether it's open or closed...
And he did, at some point, he did say he fell. He said he fell to the ground and that he lost consciousness, and then he was taken to the hospital.
Well, before he was taken to the hospital, he actually went to the shanty to report it.
But I thought that the gentleman who was supposed to report it to was not there.
Right, so he reported to the person who was there, who admitted that he and a coworker came down, both of whom said that he had fallen. As to the pins, you have plaintiff's testimony at page 367 of the record. He testified the pins were done incorrectly. They were meant to be fixed. Other workers had put them up. They were being rushed, and the pins weren't placed properly. They had to be replaced. That's at 367 of the record.
Well, there's also the issue in terms of the ladder, because he initially stated that he was standing on the ladder. He had been specifically told not to use a ladder because of his prior incidents of dizziness. And so your friend states that this shows that he did not follow instructions. He's on the ladder. He should not have been on the ladder.
If that were the only issue, and Your Honor did address it to my esteemed adversary, if the only issue was whether he fell from the ladder, then I would agree that's an issue of fact. This is a falling object case, whether he's on the ladder or he's on the floor, whether he's standing, sitting, bending down, or whatever. He was hit by a form that fell from 15 feet.
And there was no contradiction about that. There was nothing
whatsoever.
about
that. And actually, even the appellant's briefs don't dispute that. There's no contradiction whatsoever. So regardless of whether ladder, vertigo, any of those potential issues of fact may be relevant, but nothing disputes the fact that he fell from a form.
But it does it not go to his credibility?
Not on this issue. There's no evidence to rebut it whatsoever on that. On the 241, This court has the Fontaine case. So the question isn't so much whether this form was an object that had to be stored or wasn't stored. It's a question about the second sentence of Industrial Code 23-2.1A2, which is whether this was material that was improperly placed. We have the evidence about the pins. We know it was improperly placed. I agree there's an issue of fact there, and I think the lower court got that right. As to the 200, we're okay with the fact that the trial court denied our motion, but the smoking gun on this issue is the fact that Mark Howe hired all the subs, and their own contract stated specifically that they maintain control over construction, means, methods, techniques, sequences, and procedures, and for coordinating all portions of the work. That's record page 726 to 729, 737, 738, 832, 858, 859, and 1268. The question whether plaintiff took direction only from his employer is relevant. However, it's not whether Markel exercised the direction of control, but whether they had the authority to do so. This contract retains in them the authority to do that. The only authority they delegated to the employer was the authority for rigging, to control means and methods of rigging only, and that's at record, and the lower court got that right at record number, page 17. Anything else, they reserve the right to control the means and methods of the work.
Thank you.
Thank you.
Your Honor, as to plaintiff's points, yes, the lower court did acknowledge that the contract states that capital is going to control the means and method for rigging. But Your Honor, that the legal conclusion that there's a question of fact whether Markel retained the authority to control the capital scope of work beyond rigging is incorrect, Your Honor, because the operative provisions of the contract between Markel and Capital makes it very, very clear that it was only Capital who was responsible for this concrete work that it was hired to do. And that is very also in the agreement that states on item 20 that the injury producing work was performed by Capital. And Markel had no role in it or involvement in assigning this work. And as far as Markel retaining supervisory authority, yes, it did have that. But at the end of the day, Markel's witnesses testified that the means and methods for the concrete structure that Capital was involved to make, and the plaintiff's claim arises out of that, was with Capital. Your Honor, with regard to plaintiff's contention about there was no contradiction about the concrete falling on the plaintiff, Your Honor, fundamentally, the record presents sharply disputed issue as to the proximate cause. Your Honor, Capital's supervisor, Patino, he testified that plaintiff was specifically directed not to work on an elevated level, on a ladder, or even mount the forms, or even be in the area where his accident happened. And these instructions were enforced after his complaints about feeling dizziness.
Did he fall off a ladder?
Your Honor, the lower court has claimed that's a question of fact. If he had fallen from a ladder.
Is there a question of fact that something fell on him?
Your Honor, with regard to that, he has gone back and forth. And
so when has he said that nothing fell on him?
Your Honor, it's the basis of his testimony because he doesn't even know if the area that he was working was open to the sky or had a ceiling.
But
And Your
again,
Honor,
regardless, he still says that this piece of concrete fell on him.
Your Honor, I want you to focus on the fact that this court has most recently decided in the decision in William Rivera versus Sidem, where the first department, Your Honor, this court has affirmed that when the superintendent testified that he was not supposed to be was not supposed to use the proper access to the ladder that morning. And this court affirmed that when the superintendent testified that the plaintiff was not supposed to do what he had done it, that is a question of fact, and that precludes summary judgment.
Thank you.
Your Honor, just to briefly address two of the plaintiff's points. With respect to the missing pins, it's pure speculation by the plaintiff. The plaintiff also testified he doesn't know when the form was mounted or who did it. So for him,
Did the form fall?
that's a question of fact, Your Honor. The only person who says that it fell is plaintiff.
Do we have any evidence in the record contradicting that it fell?
We do, Your Honor. In fact, when he reported it to Mr. Saldero while he was still at the scene, he reported that he fell. He didn't report that he was struck by a beam that fell. Again, he's allegedly working with two other people, either, depending on which version you have, either he's on a ladder or he's handing a form up to somebody or he's getting the form handed to him from somebody. Somehow this form falls, strikes him, knocks him to the ground, and causes him to be unconscious for 15 minutes. And when specifically asked who witnessed this, he said no one. The reason that we don't have any contradictory evidence, aside from his own statement at the scene, 15, 20 minutes later when he reports it to Mr. Saldero and says, I fell, and wholly fails to mention that a beam allegedly struck him in the head, is because there's no witnesses to it. There's absolutely no other evidence than the plaintiff's own account, one of plaintiff's accounts. His accounts vary wildly, and in the first department is held consistently. And so as the second department has affirmed and taken the first court or the first department's position that where a plaintiff's credibility is called into question and he is the sole witness, which here he was, to an accident, that summary judgment is improper. There's questions of fact. I can't sit here and tell you that a beam fell on him, because there's no evidence that a beam in fact fell other than the plaintiff's own testimony as to that this allegedly happened, but somehow didn't strike any of the other workers, and no other workers that were working within feet of him saw this happen. He also neglected to report it. In several other instances, when he goes to the emergency room, he neglects to say he fell from a ladder, but says that he was struck by a beam.
Thank you.
Thank you, Your Honor.
Thank you. People v. Doctor.
Good afternoon, Your Honors. Paris DeYoung of the Legal Aid Society, here on behalf of appellant Mr. Jalen Doctor. Your Honors, the crime that Mr. Doctor committed is an extremely serious one, and our modest request for a sentence reduction here today is in no way an attempt to diminish the severity of those actions. We are making this request because we believe that the minimum here, 5 years incarceration and 5 years post-release supervision, is the minimum sentence necessary under these extraordinary circumstances to meet all the goals of our criminal justice system. And I do want to note briefly, Your Honors, my client has already served a significant portion of his prison term, and so even a reduction to just 6 years at this point would result in his immediate release. But I would like to focus the majority of my time today on the 10-year post-release supervision term. As Your Honors are aware, PRS serves two primary goals: public safety and assisting people who have been released from prison in their successful reintegration into the community. Not only do we believe that 10 years is unnecessary to accomplish these goals, we actually think that 10 years will run counter to these goals when we think about and consider the additional requirements that he'll be subject to under SORA and SARA. So under SORA, my client will be subject to lifetime registration, regardless of the length of his post-release supervision term. Moreover, he's going to be subject to SARA. Given the age of the victim in this case, the victim was 17. SARA imposes additional housing restrictions for people who are subject to the law, and those requirements include prohibiting individuals from living within 1,000 feet of any schoolyard, which includes playgrounds and any other public space associated with those places.
Is this the defendant's second conviction for this type of crime?
No, it is his first and only
First and
conviction.
only?
Yes. And again, just given what the SARA restrictions are, that makes housing virtually impossible here in New York. And Your Honor, my client's unique in that he has loving and supportive parents who are excited to assist him in his reentry. Unfortunately, their home is not SARA compliant. And what that means is that when he is released, he is going to live in a SARA compliant homeless shelter whenever a bed is available to him, instead of living with his parents, who again have been present since day one of this offense. There's also significant evidence, Your Honors, and a growing number of New York courts are acknowledging it, that these SARA restrictions can actually increase risk of recidivism. And that's because not only are they unable to find stable housing and they struggle to reconnect with their families, it also makes it harder for them to hold down a job. And we have all reason to believe that this particular individual would succeed at that. He graduated high school, he had a job at the time of the offense, and as I said, he had no prior criminal record. Lastly, Your Honors, I just want to very quickly highlight a couple of what I would deem extraordinary circumstances here. I know that is not required for Your Honors to reduce a sentence, but I do believe that they exist. The first is that there was an expert in this case who found that my client was in no way risk for sexual recidivism. They said this was a young man who made a devastating mistake. We believe it to be aberrational, and we see no risk going on to the community. He took responsibility for his actions. He admitted his guilt upon arrest. He enrolled himself in therapy right after that arrest, and he cooperated with the prosecution throughout the pendency of this case. And I want to just note this, and I want to quote it because it's so unusual. The prosecution at sentencing said, "Even 7 months, even 7 days in prison will be an extreme hardship for this particular defendant." That was reflected both obviously by the prosecutor, also defense counsel, also the expert, given the age of this individual, his small physical stature, and the lack of experience he had with the criminal justice system. And Your Honors, I can attest here today that his nearly 6 years in prison have been an extreme hardship for this young man. And we do believe these extraordinary and unique circumstances justify the modest reduction we're seeking here.
Thank you.
May it please the court, Assistant District Attorney David Crowley for the people. Let me just start with where my friend finished. The prosecutor did acknowledge the hardship of prison, but did so in furtherance for a recommendation for 9 years. The people in no way were suggesting that the sentence the defendant received was excessive. The report itself that counsel quotes about whether the defendant was any future risk, it's hard to know what to make of that. At the same time that the report said that there was no risk and that he had no cognitive distortions with respect to sexual violence, it also said he was in need of mental health treatment, sex offender treatment. And of course it said that because he committed a brutal rape, and the report was unable to give any explanation as to why, any extenuating circumstances, any reason whatsoever not to fear that he would do it again. Counsel says that in light of SORA and SARA, extended periods of supervision are unnecessary or counterproductive, but what she's taking on are the legislative determinations of the state of New York, not anything with respect to this individual defendant. Indeed, I think the policies of SORA and SARA and the fact that there are special carve-outs for sex offenders in PRS and the Less is More Act just show how concerned society is about the risk of reoffending with these particular types of consequences. So if there are no questions, I submit that the sentencing court did an able job of balancing the horrific nature of this crime with this defendant's individual mitigating factors. Thank you.
Thank you.
Your Honors, I'll be brief. Yes, the expert report did identify my client as needing sex offender treatment and continued support. He got that. He sought it out on his own before he went to prison. He successfully completed SOCTP and all of his required programming since he's been incarcerated. I also would just like to very briefly address the appeal waiver. If Your Honors have any questions, this was an obviously invalid waiver. The court simply failed to separate out the waiver of the right to appeal from the other rights that are automatically forfeited by guilty plea. Court of Appeals has made clear that that is more than sufficient to invalidate a waiver, so this court is well within its rights to adopt it to reach this issue. Lastly, my opponent did mention less is more. Your Honors, less is more does apply to post-release supervision. Even if Your Honors were to say, okay, let's reduce it to 5, he would still be subject to 2.5 years of post-release supervision, assuming all goes well. The reason less is more came into effect is because the research has shown that after the first 2 years of supervision, the benefits of supervision are greatly outweighed by the sort of impediments to one's liberty. And so we feel that 2.5 years, again, for this particular individual under these circumstances, is more enough to meet sort of these two primary goals of PRS.
Thank you. Thank you. Ans v. Leach-Tishman. Yes, whenever you're ready.
May it please, may it please the court, I'm David Lewis of Itala, Bertuna, and Caymans. And today I speak for Robert Gans. The lower court improperly dismissed the complaint in this action on the basis that Gans had not pled proximate cause and had not pled actual damages. But a reading of the complaint makes it clear that in fact those were pled. The gravamen of the malpractice, it comes from the partner Thomas telling his partner Goldstein that in his opinion there was no basis for Gans in effect to enjoin the sale of his property, when in fact the agreement particularly and specifically provides for that, and not only in the agreement, but a few days before the discussion, a few days after the default, the lawyer representing Mac tells the partner Thomas in an email that says that they're in breach of the agreement. So Thomas is on notice from the lawyer for Mac that the preferred lender, by moving forward with the auction, has violated the agreement. The next point I want to make is that our adversary complains tremendously about everything being speculative, but in the area of legal malpractice, and as in a lot of negligence, there's always an element of speculation because the issue is what failed to happen. When we talk about what failed to happen, there's an element of this is not a guess, this is the circumstances surrounding it. And the last thing I want to say is in terms of the interest as between the defendants say they're not successes in interest. The Thomas and Goldstein appear on the other law firm's website as part of that law firm. They cite an agreement that's made about goods and services that says that Robertson Brogue, RB, still is in business, but it appears that, in truth, it was swallowed up by the other firm. I'll rest my time. I'm going to hang on to.
Good afternoon, Your Honors. Jamie Wasman with Lewis, Brisbois, Bisgarden Smith, and I represent two of the defendants in this action.
Tishman.
Leach, Tishman, Fiscato, and Lample, and Leach, Tishman, Robinson, Bragg.
So, counsel, let's start with that agreement in terms of how your adversary characterized the firm as one is being swallowed up by the other. Is that accurate in terms of how the agreement lays out the relationship between the parties?
No, that's a gross mischaracterization of the actual agreement, which is annexed in support of our motion and is part of the record. The agreement sets forth the particular assets that are being purchased, as well as the particular assets that are being excluded. The agreement also identifies the liabilities that are being assumed and the liabilities that are not being assumed. One of the excluded liabilities is the liability for a suit just like this, something for alleged actions that occurred prior to the execution of the agreement. And this particular execution occurred in May 2022, and the alleged deviations occurred in 2021. So this is precisely the type of liability that was not a part of the agreement. So it was a gross mischaracterization of this agreement. And the trial court got it 100% correct when it held that the most important and the most critical factor for the de facto, to determine whether there was a de facto merger, which is what is alleged, is a continuity of ownership. Not only does the complaint not allege that there was continuity of ownership, the documentary evidence in the form of both the articles of incorporation for Leach, Tishman, Robinson, Bragg, as well as the asset purchase agreement, refute any such claim, because the asset purchase agreement identifies all of the owners of Robinson Bragg, and the articles of incorporation clearly identifies all of the owners of the new entity which purchased limited assets of Robinson Brogg. If you compare those two documents, which are both part of the record, you can clearly see that there is absolutely no overlap between the ownership. So this department has expressly said that in the event that continuity of ownership is not alleged and does not exist, then there cannot be any application of.
So you need to have all of the members of Robinson and Brogg become members of the new firm in order for there to be a de facto merger? Is that
Your
what you're saying?
Honor, I would say no. That would be a generous interpretation, but there has to be some continuity of ownership. There's absolutely none here. What I heard from my friend here is that a couple of the partners that were partners at Robinson Brogg have now become partners at Leach Tishman, and not Leach Tishman Robinson Brogg. And that's one distinction that I want to make clear, is that this agreement was between Robinson Brogg and Leach Tishman Robinson Brogg, not Leach Tishman and Robinson Brogg. So the fact that Leach Tishman is named here is completely improper. And in addition to the fact that there is no continuity of ownership, the other factors that are required to apply the de facto merger doctrine have not been alleged, and several are refuted by the documentary evidence. And I know that the red light is on, but on top of that, because a legal malpractice claim was not adequately stated as against Robinson Brogg, it follows that the claim on the successor liability basis against my client was rightfully dismissed as well.
Thank you.
Thank you.
May it please the court. Marion Rice from Labatt Balkan, representing Robinson Brogg and the two named individual attorneys in the caption. I hesitate to say this, but the speculative nature of legal malpractice claims is why this court and almost every court in the state often dismisses legal malpractice claims. It is one of the few torts where you have a higher standard of proof, a but-for causation, that needs to be pled with some specific facts here. In this particular action that was before Justice Patel, there was a claim that my clients committed malpractice primarily, excuse me, because of the one issue that was raised by plaintiff's counsel, and that is that Mr. Thomas supposedly gave wrong advice as to what the contents of the joint venture operating agreement and loan said. That advice was 100% correct. There is nothing in the joint venture agreements that says the preferred member must get the permission of Mac Realty or the mezzanine lender before they can foreclose a UCC foreclosure. Now, this is not property. This is a UCC foreclosure on a membership interest that Mr. Gans put up to secure a loan from the preferred member. Now, to be very clear, my client did not represent them in connection with that deal. They did represent them in connection with the $150 million deal with the Mac Realty and the mezzanine lender. But that came after the preferred member deal here. So when the deal was struck with Mac Realty insisted, as any lender lending that kind of money would, that he would insist the preferred member sign a subordination agreement so that their rights would come in ahead of the preferred member. And they did, and they signed the subrogation agreement. Mr. Thomas looked at the preferred member agreement, and it does not require notice to Mac Realty. But the Mac Realty agreement does say if somebody tries to sell the property, changes the ownership, that's a breach of the Mac Realty agreement, not a breach of the joint venture agreement. The joint venture preferred member was entitled, once they weren't paid, to notice a UCC foreclosure sale. And because it's a UCC foreclosure sale and not a mortgage foreclosure, the only way to stop it is to say it was not done in accordance, or A, the money wasn't owed, which we all know was absolutely the case. A lot of money was owed in this case. And the second part of it is that, was it procedurally done correctly? And there's never been any insinuation by anyone it was not procedurally done correctly.
Could it be stopped by a filing for bankruptcy?
Here's the problem with that. Now, the complaint originally said that Robinson Brogg never advised the plaintiff of bankruptcy. Well, when I first looked at the case, they spent 2 months, 3 months almost, during the height of the pandemic in March through June of 2020, preparing bankruptcy petitions for all of Mr. Gans' companies. He had a large portfolio of commercial businesses in New York, which during the pandemic was in horrible shape. His problem stemmed from the Taj Mahal down in Atlantic City that went under years before that. Excuse me. But the bottom line is, no, Mr. Gant took a look at this and said, if I have to file on every one of my businesses here because they're going under and I want to try and save them, my personal guarantees are going to kick in.
And it's it's speculative at this point that the bankruptcy, a bankruptcy filing would have allowed him to keep his equity in the property.
Not only would it not have allowed him, but the one time he got a buyer, he still couldn't get any equity out of it. He got a buyer for this 28th Street property, which was the subject of the preferred member's ownership. And the purchase price, the best purchase price he could get was $27 million. And the reason the preferred member would not consent to the sale and allow it to go to a third party for $27 million is because more than $29 million or more than $30 million was owed from the buyout price for the first lender, the buyout price for the mezzanine lender, and then the buyout price for the preferred member, who was the one who was really pushing this.
But didn't the preferred member allow the property to be sold for $100,000, well below what it was valued at?
Well, yes and no. The preferred member, it was acquired by an affiliate of the preferred member. So it really was not something that was well below that. But here's the kicker, and I know I'm over my time, but this is so important. There is no way anybody could have anticipated that a preferred member would have been willing to let their membership interest in this building be wiped out, which the subordination agreement said it was going to be if they filed for their UCC foreclosure. No business person, nobody could conceive while this attorney would not consent to the obvious, logical, let's try and play this out. Let's see if we can get everybody on board. Let's see if we can get a better buyer. Let's see if we can sell it and everybody gets some money out of it. That's a normal thing. Nobody could understand why the attorney would not agree to it until 5 days after the foreclosure action, he filed a suit trying to claim that Mac Realty's lien, the $150 million lien, was not valid.
Thank you.
Thank you. Judge Schechter didn't buy that. Thank you.
Just briefly, the record at 331 to 333 and at pages 267 and 268 contain the joint venture agreement, which provides for notice that has to be given if there's going to be action to foreclose on the loan. It's there in the agreement, and that's the basis that Thomas looked at and, was asked about and didn't look at when he gave his answer. So that's the first thing.
Was the answer that was given the but for here?
I'm sorry?
The answer that was given by Thomas, but for that answer, would things have been different? Would your client not have sustained the damages?
I think if the proper answer was given, then Robinson Brogg would have gotten an injunction to stop the auction of Gans's property. But by giving that advice, they decided there was no basis for an injunction when that provision in the agreement actually gives a basis. I'm sorry, I was waiting for a follow-up.
I don't have one.
Okay. With regard to the bankruptcy, the problem with the bankruptcy argument is that what they did in 2020, or 2020, of sending Gans blank forms and saying, fill this in, has nothing to do with the 2021 defaults, which led to Gans looking toward bankruptcy. So the fact that they did it earlier is really of no moment.
So them telling him a second time to file for bankruptcy, would that have changed the foreclosure of the property that occurred?
If there was a second opportunity for bankruptcy, and at that point Gans wanted to put all his property into bankruptcy, that would have been a change.
Thank you.
Thank you.
Robinson Brogg, you have time for rebuttal.
3 really quick points here. The provision that was cited by counsel right now is not in the joint venture. Pages 331 to 333 in the record is the Mac Realty loan documents. Now, they did not cite 6.2.10 in their main brief. As a footnote in our brief said, you've waived that argument. You didn't raise it to this court before. In their reply, they cite on page 12 of their reply in detail, respondents erroneously claim no legal basis exists for Gans to seek a stay of the auction sale, which is authorized by the UCC. But section 6.2.10 of the joint venture agreement states that the borrower shall not sell or in any way dispose of any individual property without the written consent of the lender. That is in the Mac Realty loan documents. The cite to the record that appears after their sentence is record 331 to 333. That is not the joint venture agreements. That is the Mac Realty. And that is why Philip Thomas's advice was 100% correct. Second point about the bankruptcy, really quickly, Mr. Gann's argument was not that he wanted to put all of his properties into bankruptcy. He wanted to just put the 28th Street property into bankruptcy. He could not do that because all the properties were cross-collateralized. So the argument in the briefs, which is he wanted a targeted bankruptcy, is meaningless. And as Judge Patel found, you just couldn't do that. And that's why Judge Patel's decision should be affirmed.
Thank you. Goss Lawson v. Matco Service Corporation. Yes.
Good afternoon. You may please the court. David Levy for the appellant. An abrupt stop, a claim of an abrupt stop by a leading vehicle, in and of itself, is not sufficient to provide a non-negligent explanation for a rear-end accident.
Why did your client stop abruptly?
Well, she was at a yield-controlled merge ramp when the incident occurred. So her opinion at that moment, her obligation was, is it safe for me to proceed and enter a major highway called the Major Deegan Expressway at 3 p.m. on a Thursday in the Bronx? Her decision at that point was, perhaps it's not. There's a vehicle in front of me. The duty of the driver behind her was to maintain a safe distance behind.
Her decision was based upon the fact that it was yield and she's trying to get onto the highway, but she has to look to see whether or not she can safely merge into traffic.
Correct. And her determination was that it was not safe at that point. His determination was, and he claims in his own driver's statement and in his affidavit, which I have a whole section on why that's a contradictory feigned affidavit, but let's assume under best viewpoint for them. He admits that I saw her begin to proceed, and I turned my head to see if it was safe to do so. When I turned back, she was at a complete stop. So he admits on the record that I failed to maintain a direct line of sight with the vehicle in front of me. He could have stopped his vehicle when he was looking, but he continued driving.
So you're saying that his explanation for having rear-ended your client's vehicle is not a non-negligent explanation?
His explanation is not only a non-negligent explanation, it is a negligent explanation because he admits that I wasn't keeping a direct line of sight with the vehicle directly in front of me. And that was his only obligation at that point in time. He was required to maintain a safe distance. She was doing something completely separate. She was at that moment, do I have the right to enter into this dangerous intersection? And she was doing that, in my opinion, in our position, appropriately, exactly what she was supposed to do. And I cite a bunch of cases that stand for these principles, that this court has held the same principles and supported these principles before. The most factually similar, we believe, is the Diller case, which is a 2000 case. But in that case, a police officer also similarly claimed that the vehicle came to an abrupt stop. The police officer admitted that she turned to the right, continued driving forward, and then turned back, and at that moment was confronted with a plaintiff's car, which was completely stopped. That admission, this court stated, fell below the standard of care that a driver from the rear is required to maintain when driving. And whether that vehicle stopped because of a light, the court said, or traffic congestion, it's irrelevant because that driver failed to maintain a constant line of sight. And
You have time on rebuttal. Thank you.
Thank you.
May it please the court, Nicholas Calabria with the law firm of Romney, Demers, and McManus for the respondent, Matco Service Corp. This is a motion for summary judgment by the plaintiff before depositions were held in the case, so it just became a battle of affidavits. The court...
And photos.
Correct, and photos.
We do have the photos of the damage and of the collision.
Correct. And we also have a police report.
Certified?
Excuse me?
Certified, the police report?
So
is it admissible?
Yes, it is. I believe it's certified.
Yeah, I believe it was, Your Honor.
So what I thought was interesting is your client seemed to be of the opinion that a yield does not mean stop. That if it's a yield and you're merging onto traffic, somehow that doesn't mean stop, or doesn't mean that the vehicle in front of you would come to a full stop.
No, I believe the affidavits and the
He kind of
statements.
said that, didn't he? He said, I don't know why she was at a complete stop. It didn't make sense.
Yeah, but she had passed the yield. This was in the merge now. There's an excellent drawing that he did at page 77 that shows the way, his drawing, the roads merged.
I think a few of us are familiar. A few of us are familiar with that.
Yeah, I am also.
Yeah,
coming
exactly.
from the Bronx courthouse.
Right, but that makes it even the more that's even more interesting, because if she had passed a yield, she still has to stop if there's oncoming traffic.
Right.
Or at least he has to anticipate that she may stop.
Right. So, and what he's testified to is he came up upon the car, stopped. The cars ahead of her started to move on. She began to move on. He turned around, he looked, then proceeded, and then came into the double merge, and she stopped completely with no oncoming traffic. She said there was another car in front of her. She said she struck that car. In the police accident report, they say it was first reported by the fire department as a 3-motor vehicle accident, but then the report was updated. No, there was only a 2-motor vehicle accident. So I don't even know, again, we're with these battles of affidavits with no depositions. The depositions have been held since then, and I think on a full record, we'll have a better understanding of what actually happened in this case.
Based upon the affidavits that we do have, based upon the certified police report, and based upon the photos and the fact that he rear-ended her, does that not give us enough in terms of the motion? Isn't that sufficient?
I believe that his affidavit gave a non-negligent reason for the collision from his perspective. It was from her stopping for no reason whatsoever as she merged onto a road with no oncoming traffic.
But isn't it clear, isn't it clear, again, based upon the evidence in the record, that he did not maintain a safe distance?
Well, he was maintaining a distance, and then she stopped, and he had to stop and couldn't stop quick enough. Does the requirement that you maintain a safe distance end at some point in time? I mean, isn't it ongoing? Of course it's ongoing, but when someone jams on their brakes for no apparent reason with an open lane of travel, your reaction time it definitely changes, and that would make it a non-negligent reason. She came to a sudden stop for no reason. And again, based on this, just affidavits, before we have depositions in these cases, I think the court was correct to deny the plaintiff's motion. Thank you.
Thank you.
Your Honor, just to adjust the points that were raised, yield does mean stop. In his own affidavit, he says in paragraph 5, I brought my vehicle to a stop behind a line of other vehicles waiting to enter an intersection. So he himself had stopped waiting to enter.
Yes, but he does state that when he turned, there was no oncoming traffic, so that's why he thought that she was going to go, because he didn't see any traffic.
He didn't see traffic,
right?
But his obligation was to keep his eyes on the vehicle in front of him. Her obligation was to determine, is it safe for me to proceed?
Well, what he was saying, I assume, is that because it was clear did not see any oncoming traffic, so therefore he believed it was clear for him to merge. He believed, therefore, it would have been clear for her to merge as well.
If he had maintained the line of sight, he would not have made that improper assumption.
When I read the affidavit or the statement provided by the defendant, I don't read that she was moving and suddenly stopped. I read that he put his head, he's looking somewhere else, and then when he looks again at the vehicle in front, that vehicle is stopped already, but now he's already moving. So he didn't see that vehicle moving at any point, which means that he ran into her because he didn't see that that vehicle had stopped there and had not moved when he began to move his vehicle.
That's precisely what places this case as identically to Diller. He turned his head around, and he doesn't say she entered the intersection. In both his driver's statement and in his affidavit, he says, I saw her begin to enter. And at that point, I checked to see if it was safe for me to enter. As I turned my head back around, meaning as I lost sight and continued driving, she was at a complete stop. Had he maintained a line of sight, again, that wouldn't have happened. He mentioned the diagram. So look, the impact that he drew himself is before the intersection. It's upon entering the intersection.
Thank
So
you.
she
Thank
had
you both.
Thank you, Your Honor.
Barrero v. New York City Department of Social Services.
Good afternoon.
Good afternoon.
May it please the court. My name is Jason Barrero, appellant petitioner appearing pro se. This appeal presents a narrow jurisdictional issue where the Supreme Court erred in dismissing this Article 78 proceeding for failure to exhaust administrative remedies under FOL, where exhaustion was either completed by operation of law or could not be resolved on the face of the record. FOL's deadlines are mandatory. When the agency fails to timely transmit a complete determination, exhaustion is completed by constructive denial. The governing framework here is straightforward. FOL requires timely transmission of a complete determination. Failure to comply constitutes constructive denial. Constructive denial completes exhaustion as a matter of law. Where the record is unclear, exhaustion cannot be resolved against the requester at the pleading stage. I rest some questions.
No, but you have time on rebuttal.
Oh, I rest my.
Okay, thank you.
Good afternoon, Your Honors. May it please the court, I'm Alan Racinas. I represent the respondents. Your Honors, this case has a lot of factual details, but the bottom line is this. The appellant never appealed the agency determination that he's now trying to challenge, which is the April 1st agency determination on his FOIL request of March 20th. This is all dates of 2024.
Was he informed that he could appeal that?
Was he? Well, I mean, he says he never got the physical letter, Your Honor.
Exactly.
Yeah, but we emailed it to the agency, emailed it to the address, or sorry, mailed it by snail mail to the address that he provided, and also sent them an email saying, you can. We've on April 1st saying, we've made your determination. You can ask us for. We can email it to you if you'd like. But the important other point to note, Your Honor, is even if it were a constructive denial, which it wasn't, because again, the agency did provide a response. He did not serve the appeal or send the appeal within the time frame that would be required if it had been a constructive denial, because the time frame for that would have started around April 3rd. He didn't send along his first letter here for his first attempt at appealing until May 7th.
Why was it not a constructive denial?
I'm sorry, Your Honor?
Why was it not a constructive denial?
Because the agency did everything it could to send. The agency did send an actual response and did everything it could to get it to the appellant. He sent it to the mailing address that he provided, the physical mailing address, and by email it told him that it had made the determination. So, either whether you look at it as a constructive denial. I mean, again, even if you look at it as a constructive denial, he didn't timely appeal that constructive denial. And it was not, in fact, a constructive denial because the agency did respond and made every effort to get him the response. It's still not clear from the record why it was that he never claimed the letter that was sent to his address. And then, there was no constructive denial. Even if there had been a constructive denial, he didn't file an appeal timely. And he also says in his reply, I just want to note quickly, he says, well, he made an amended FOIL request in both the May letter and the May 7th letter and the June 12th letter. But even if that were true, and the agency took the position that it was just, I mean, if you look at the May letter and the June letter, it's item number 4 that has the so-called amended request, which is really just a particular, asking for a particular kind of document related to item number 3, which is an Excel spreadsheet. But even setting that aside, even if it had in fact been an amended FOIL request, he never appealed any response to that request either, Your Honors. So
Thank you.
that's it, Your Honors. Thank you.
If I may rebut
Yes.
the April 1st email, the agency's position depends on what was transmitted and when. Because the April 1st email contained only a notice and no determination, no complete determination was timely transmitted within the statutory period. Under FOIL, that failure constituted constructive denial, and at minimum creates a record ambiguity that cannot be resolved against the requester at the jurisdictional stage.
Anything further?
The record is the problem here. It's narrow. The questions cannot be resolved against the requester at the jurisdictional stage.
Thank you. Thank you both. Last case for argument is People v. Mitchell Thompson. Yes. Whenever you're ready.
May it please the court, Maya Stevenson for the appellant Mitchell Thompson. Your Honors, this court should reduce Mr. Thompson's sentence for 2 reasons. First, Mr. Thompson's behavior, while very serious, was the product of mental health and substance abuse issues, not his character. And second, Mr. Thompson is a first-time violent felony offender, demonstrating that this behavior was a drastic deviation from his normal behavior in society and was also in line with the previously mentioned struggles.
And was also in line with, I'm sorry?
His previously mentioned struggles, Your Honor.
His previous,
First, I would like to draw this court's attention to the fact that there is no appeal waiver at issue in this case. And second, I would like to draw this court's attention to the Court of Appeals directions when determining whether a sentence is excessive. This court is required to consider whether the crime charged,
I will say that I noted that in your brief, the cases that you cited in support of reduction were clearly distinguishable from the cases, from this particular case. In fact, you cited one case, and I think it was a typo. You said it was an attempted murder, and in fact, it was a murder. It was a homicide. In this particular case, the defendant shot a stranger as he was attempting to rob the individual. He attempted to rob the individual when the individual would not give him his property or what have you. He shot him in the back as the individual, as the victim tried to run away from the defendant. The defendant shot him twice in the back. The defendant had also displayed that weapon. I don't recall whether he discharged it earlier in the day, but he shot the man in the back twice as the man is trying to run from him as he is attempting to rob him. So he was sentenced to 20 years plus 5 years post-release supervision. So what is it that you wish us to reduce this to?
Well, first, Your Honor, are you referencing People versus Reyes?
There are a couple of cases that were actually cited incorrectly, but what is it that you want us to reduce this to?
Your Honor, I'm asking for a modest reduction to what this court feels is appropriate. We are not asking for the minimum allowable, but it is of note that Mr. Thompson's sentence is more than double that of the minimum.
It's more than double that of?
Of the minimum for this charge. Second, Your Honor, an evaluation of these factors for Mr. Thompson should make this court consider reducing his sentence and modifying it.
The factors that you speak of is the mitigation, the mental health issues, which factors?
The Court of Appeals directions when determining whether a sentence is excessive, considering the crime charge, the circumstances of the individual before the court, and the purposes of a penal sanction. So yes, in combination with the mitigating factors of this case, as well as the purposes of a penal sanction, such as deterrence, rehabilitation, and even societal protection.
So you talked about mental health issues. Was this documented at all?
Your Honor, it was documented and self-reported in Mr. Thompson's PSR that he suffered.
It was self-reported. Where was the documentation?
In the PSR on pages 5 and 6, Mr. Thompson talks about his struggles with depression and anxiety.
Again, self-reporting. Was there any? He talked about his daughter dying 2 years before. But is there anything in terms of that he was undergoing any type of psychiatric care or anything of that nature?
Unfortunately, Your Honor, Mr. Thompson does not describe any treatment for his mental health issues, which is why this case is so relevant. Mr. Thompson was walking through life suffering under the weight of severe mental health issues, depression, anxiety, hereditary struggles, including bipolar disorder.
Thank you.
Good afternoon. May it please the court. Margaret Crookston for the people. The sentence was fair and appropriate based, as noted, on the horrific nature of the crime and the fact that after the crime, he fled state lines.
Well, first he went to the Bronx, then he went to Jersey, then he went to Delaware?
Yes, that is correct. And it was in Delaware where he was eventually arrested and then brought back to New York. Had attempted to conceal his involvement in the crime immediately after. He changed his clothes, he got a burner phone, and the evidence in this case was very strong. It is very likely he would have been found guilty on the top charged crimes, which carried a possibility of a life sentence. And this was the specific plea that he was seeking to avoid the possibility of a life sentence. And if there are no further questions, we ask that you affirm.
Thank you.
Thank you.
So just so you're clear, People v. Reyes, you stated that the court reduced sentence for second-degree murder to 8 years for a defendant with psychotic disorder in light of defendant's lack of criminal history and recent loss of his mother. That was an attempted murder. That was not a murder. Also, you talked about, in your brief, you refer to cases. For one case, there was an individual who had mental health issues and the sentence was reduced. That was documented, and also I think the gentleman, if I'm not mistaken, was a Vietnam vet and was also suffering from post-traumatic stress.
Yes, Your Honor. Any omissions, which unfortunately I'm not sure about enough to clarify at this moment, were unintentional. However, the relevance of those cases remains because all of those cases did consider the mental health history of the individuals involved. And I think Reyes is especially appropriate because Reyes notes Mr. Reyes struggles with grief, mental health issues, and while Mr. Thompson's issues in this case of note are not as severe documented, they are relevant and of a similar nature. Second, to the government's point about Mr. Thompson fleeing or being apprehended in a different state, Mr. Thompson did take responsibility for this crime, and he did say that it should not have happened. Mr. Thompson was impaired to the point that he could not even remember what happened, let alone remember attempting to hurt someone intentionally. Thank you, Your Honors.
Thank you.
Please rise.